produced it. It matters as to whether this witness had anything to do with it.
I'll try to lay a proper predicate.
It looks to me like we received it from the Attorney General's office.
Mr. Hardin, you can take the witness on voir dire and ask him.
Yes. Mr. Penley, of this particular exhibit, did you have anything to do with preparing it?
I don't recognize this document. I don't recall preparing this. I don't believe it's mine.
Okay, that's all I have, Judge.
Do you remember ever seeing it?
I've seen it in the documents for this trial. I've seen it in the discovery.
You produced it in response to your subpoena, yes?
I don't know that.
He didn't produce.
Hold on, I'm asking the question.
I don't know that I did.
Okay, we can go back and look.
And if I did, I don't know that I prepared it. Perhaps I received it some other way.
The suggestions on this list are suggestions of things that the office might do. Questions it might answer in connection with the investigation, right?
I agree with that.
Yeah. And it says, can we talk to the AUSA Alan Bowie, right?
Correct.
And you've already testified you didn't do that, yes?
Right, I did not do that.
And none of the other questions, how was the document created? How was the document encrypted? What did he encrypt it with? What application did he use? You never got the answers to any of those questions, did you?
No, I did not.
Doesn't that seem like important information you might want to know?
No, not based on what I learned on August the 6th.
Okay, so I want to fast forward in your mind now to August 12th. We're going in chronological order if you couldn't tell. August 12th, you believe, and your testimony on direct was, you believe Ken Paxton was no longer supporting you, true?
That's true.
Yeah, and you came to that conclusion after the meeting with Nate Paul and his lawyers at which the Attorney General was present, yes?
Based on what the Attorney General said, that was opposite of what he had told me 3 or 4 days earlier.
And now, if you would, let's take a look, Mr. Arroyo, at AG 1013. You and the deputies on August 13th, the day after you say you no longer felt supported by Ken Paxton, you got in a circle with your deputies, yes?
I didn't get in a circle. I briefed Jeff Mateer on what had happened the previous day.
When you produced this document in response to a subpoena, you blacked out the top, you whited out the top of it, right?
Yes, because
I just need an answer to my question.
Yes, I did. I redacted it.
Yes, and we don't know what's under there because you didn't show us, correct?
That's true.
Now we go to the rest of this item. These are your handwritten notes from a meeting, true?
Yes.
And below that, Mr. Arroyo, if you can blow up the text to the right below that. It says, call Dan Cogdill.
Yes.
That's what you wrote, right?
Absolutely.
We're talking about that guy?
Yes, the guy in the good-looking sport coat over here.
It says, ask him if Maxwell and I say go no further with this. Did you call Dan Cogdill?
No, we did not, but we considered it.
Object non-responsive to anything after no.
Sustained.
Below that, Mr. Roy, if you could highlight that, it says possible bribery.
Yes, I wrote that.
On August 13th of 2020, you had absolutely no evidence, physical, documentary, eyewitness, or circumstantial, that Ken Paxton was being bribed by anyone, did you?
I disagree with your statement. I had circumstantial evidence.
Oh, you had circumstantial evidence?
Yes.
Well, at some point on August 13th, did you go to your boss, Ken Paxton, and say, Attorney General, I'm concerned. I have circumstantial evidence that you've taken a bribe. Did you do that?
Not on the 13th of August. I did it later.
You didn't do that because you knew you would get fired, right?
I said possible bribery. I didn't have evidence to confront him with, not at that time.
Oh, but you just told the ladies and gentlemen of the jury you had circumstantial evidence.
Yeah.
So did you confront him with the circumstantial evidence?
No, the circumstantial
Object
evidence.
now responsive to everything
Mr.
after
Kennedy,
no.
please be allowed to respond. I'm just begging.
Sustained. Your objections.
Thank you. Mr. Penley, below that it says, if you can zoom back out, Mr. Arroyo, he's using OAG/playing KP. Did you tell your boss you thought that Nate Paul was playing him?
Not on August the 13th.
Why not on that day? You had his phone number, right?
I'm sorry?
You had Ken Paxton's phone number, right?
Yes, I did.
Why didn't you confront Ken Paxton with your circumstantial evidence of bribery and the idea that Nate Paul was playing him on August 13?
Because I was trying to find a way to convince him to listen to reason and get away from this investigation, which I thought was highly dangerous to him and harmful to the office and injurious to the respect for the law in the state of Texas.
But also because if you had done that, you should expect to get fired, don't you think?
I could have been, and I was concerned about getting fired ever since Ken Paxton did a 180 and turned against me in the August 12th meeting, all the way to the end.
Okay. So just to be clear for the ladies and gentlemen of the jury, your concerns about bribery did not arrive until you thought Ken Paxton might fire you, yes?
No, that's not correct. You're misstating what I thought.
I have your notes here.
Yes.
This is the first document I've ever seen where you've written the words possible bribery. Will you agree?
I don't have all the documents I've written. I've written a lot, so I can't agree to that unless you want to show me all the documents. I began to be very concerned about what was going on in his mind when, on about August the 8th, more or less, I told him I recommended closing the investigation. He looked me in the eye and said, okay, fine. All I ask you to do is meet with him and tell him. And then 2 days later, he told me he wanted to attend the meeting. And then in the meeting, when I announced to Mr. Paul and Mr. Wynn, I recommended we close the investigation because the metadata theory didn't prove a crime, Ken Paxton began making negative comments to me.
I'm going to object to the narrative.
Sustained.
Appreciate your answer, Mr. Penley, but my question was a little bit different. On August 12th, by August 12th, you thought, this guy might fire me, yeah?
I did.
On August 13th, you wrote down, maybe he's being bribed, yeah?
Yes, because I thought that.
And you didn't confront him that day because to do so probably would have resulted in you being fired, yes?
Could be.
The safer strategy is to wait a month and go to the FBI with whatever circumstantial evidence you have and adopt whistleblower status for the same information, right?
No, I don't agree with your characterization.
Okay, in any event, in this memo you say that the metadata is inconclusive, right?
I'm sorry, where are you pointing me to?
Zoom back out, Eric, if you would, please. Yep, metadata is inconclusive. No proof of crime. No disproof of crime either, right?
I wrote down metadata is inconclusive, no proof of crime, and that was my belief at that time, and it still is.
In any event, I think you can tell the jury, and that we'll agree, you didn't do any investigating after that, right?
No, that's not true. I tried to investigate. I tried to get the rest of the documents that Nate Paul and Michael Wynn had told me they had on August 5th. They told me they'd gotten a bunch of documents from Judge Lane, and I never felt like they'd given me all the documents.
You had already told Nate Paul and his lawyer the day before that you were going to close the investigation before you had those documents. True?
That's true. And the Attorney General didn't accept
Jack
it.
not responsive to anything after true.
Sustained.
All right. I'm going to show you what's marked as Exhibit AG 1014, please. We're going to move ahead in time from August 13th of 2020 to September 4th of 2020. Can you see this document in front of you on the screen? Or in your hand? You've got a copy of it physically.
Yes, I think I can see it better on the screen if you'll blow it up. Thank you.
This is an email from General Counsel. This is Leslie French at the OAG, and she's sending it to FLD Contracts. It says, FLD, please see the attached partially executed contract and disclosures from Mr. Kamak. I have reviewed the disclosure statement of Brandon Kamak and am satisfied with the choice of outside counsel for this matter. Do you see that?
I do see that.
Okay. And on September 4th, you got the DocuSign that day, yes?
I've said in writing that I got it that day, but now that I've reviewed a lot more evidence, I think I made a mistake, and I believe I've got it for the first time on September the 16th is when it reached my email inbox.
Well, that's not what you testified to under oath before the House Board of Managers, is it?
That's why I said I made a mistake.
Yeah.
You're correct.
And when you and I think you'll agree, I'm not going to have to pull your transcript out. You testified to the House Board of Managers and their investigators that you got it on September 4th, and then you went on vacation and said, I'll take care of that when I get back. That's what you told them, yes? And now you're telling a different story, yes?
Well, you've asked two questions at least. I'll answer it this way if I may. Yes, I told the House managers I thought the date I first received the executive approval memorandum was on September the 3rd or 4th, whatever date is in the transcript. I don't argue with that. I now believe I first received it on September the 16th, so I'm correcting my testimony.
You're correcting your testimony that you gave to the House Impeachment Board's investigators, yes?
Yes, that's true.
We should believe what you're saying today and not then, yes?
Yes.
Okay. Our next exhibit in time, if you would, we're going to go back to exhibit AG 88. I'm going to show you the next page.
Thank you.
Your Honor, because it was, if I may, because this was a group offer, they're all, of course, Exhibit 88. If counsel could, on each one of these pages where he does it for us, give it some type of identifying so we can know and be able to pull back up later.
Well, they're already in. I'll identify it by Bates number if that's okay. So, Mr. Arroyo, if you'll go to the Bates ending in 8.
I realize they're in evidence. What I would like is a Bates number each time so I know which one to look for.
Would you accommodate him, please?
We'll do our best. Yes. Mr. Arroyo, go to page ending in 8. Give me all the text, Eric, if you would. This email is sent from Mark Penley to Brittany Hornsey, copying Drew Wicker. Hi, Brittany. I received a voicemail from the general today. He is requesting that all documents I have on the Nathan Paul matter be copied and given to Elise. Did I read that correctly?
You did.
The Attorney General just sent you to the showers, didn't he?
I'm sorry?
He just came to the mound and took the ball out of your hand. Said, give me the file. I'll take it from here. Yes?
He didn't say that.
That's what you should have inferred from that, right? The Attorney General came and got the file from you. Yes?
You're asking me to speculate. I don't know what was in his mind. I know I got a voicemail from him while I was on vacation asking me to get the file to one of the executive assistants on the executive floor, which I did.
You knew that was not a good sign, right?
No, I'd been given a warning that he was working up an outside counsel contract, and that was consistent with the idea that he was going around me and David Maxwell and trying to hire outside counsel.
He's taken the ball out of your hands, yes?
That's your phrase. I'll accept it if you want me to.
Okay, I do. You gonna accept it? He took the ball out of
I'll
your
accept
hands.
that he was trying to take the case out of my hands. There was no ball.
Very good. Let's move to Exhibit AG 1015, if you would. And these are your notes from a side huddle with Jeff Mateer, Blake Brickman, and Ryan Bangert, yes?
Yes, that's correct.
And at the bottom, we've got more redactions, yes?
Yes, they were irrelevant topics that came up in a meeting that had nothing to do with this case.
Well, I guess we'll have to take your word for it, won't we?
Well, yeah.
Below that, it says NP, file returned, Joe Brown, Cliff Strickland, outside counsel contract. So you knew about it.
Yes, the purpose of the meeting with Jeff was so he could update me on things that had gone on during the week I was gone. And he told me that the Attorney General had considered hiring Joe Brown, a former United States attorney and former district attorney in Sherman. He'd been the U.S. attorney in the Eastern District of Texas. He also, I believe, had conducted a phone interview with Cliff Strickland, an attorney in Denver.
All right, let's move ahead in time a little bit. May I approach the witness, Your Honor? Mr. Penley, I'm showing you what's been marked as Exhibit AG 124. Eric, would you bring that up, please? This is the second referral from the Travis County District Attorney's Office to Brandon Kamak on September 23rd of 2020, yes?
Yes,
And when you made your report to the FBI, you didn't know about this, true?
that's true.
And when you, I believe the word you used on direct was apoplectic.
Yes,
When you were apoplectic about the grand jury subpoenas being served by Brandon Kamak, it was because you believed they were being used for civil discovery in a criminal matter, true?
that's true.
But in fact, they were related to this second referral in a bid rigging investigation that had been referred to the Travis County District Attorney's Office over to Brandon Kamak.
You lost me on the second question. Could you repeat that, please?
Yeah, let me try again. The grand jury subpoenas Mr. Kamak was serving were relating to this referral in a bid rigging investigation that had been made from Travis County District Attorney's Office to Brandon Kamak. True?
That's not completely true. It's partially true.
It's a lot true, isn't it?
It's partially true. I'll explain if you want me to.
You can do that on redirect, I bet. We'll try. But here's what I want you to understand and want you to appreciate and agree with me on. You didn't know about this, and the subpoenas that Mr. Kamak was serving were related to this referral. Yes?
A, I didn't know about this. I agree. B, all of the 39 grand jury subpoenas he obtained from Travis County did not relate to referral number 2. Part of them referred to referral number 1.
Thank you. We're going to move to Exhibit AG 92.
I do not believe 124 was admitted previously.
We move for admission of AG 124.
Any objection? That's the document Mr. Harden, he had been working from before that one you were just handed.
He has seen 124, and this is 92.
I have no objection.
Show that Exhibit 124 is admitted into evidence. And now are you offering another?
AG 92, Mr. President.
Any objection on this one, Mr. Harden?
No, Your Honor.
Show that Exhibit 92 be admitted into evidence. Continue.
Mr. Penley, after 10 days here in Exhibit AG 92, you admit, or you finally state, I'm not signing the outside counsel contract. Yeah?
You said after 10 days. What? You lost me at 10
Well,
days.
your testimony today was that you got the outside counsel contract DocuSign on September 14th. You told them you got it on September 4th. Whether you've had it for 10 days or 20 days, you are now finally telling someone, I'm not signing it. Yes?
I received it on September the 16th, as I previously stated. So 8 days later, after the Attorney General called me and asked me to sign the outside counsel contract, I told him I could not and I would not, and I gave him all the reasons why. He told me to talk to Jeff Mateer and to forward this contract to Jeff Mateer, which
All right.
I did.
Let's move to Exhibit AG 1017, Eric. These are the notes that have already been entered in evidence, I guess, on both sides. But these are your notes from September 26, right?
Yes, these are my after-meeting notes on September 26 from McKinney.
Okay. This is discussion about hiring outside counsel, at least in part, yes?
Yes, that was discussed.
Okay, Eric, zoom in on the last half of the page, please. Higher, there you go, stop. Do you see the line about 4 lines down? It says, I said. Do you see that?
Yes.
It says, I said I don't need him, and we shouldn't be spending money on him when we can't give raises to our employees.
Yes, I see that.
You said that, didn't you?
I did.
None of that is your business or decision or authority at the Office of the Attorney General, is it?
I don't totally agree with you. I don't have the ultimate authority, but I have a duty to tell him about things going on in my area of responsibility. We couldn't give raises to our people. I felt like he was wasting money on outside counsel on an improper investigation, and I was trying to express that to him.
Do you understand that there are 900 outside counsel contracts every 2 years at the Office of the Attorney General?
I didn't know that, but I'll take your word for it.
And your explanation here, for one reason Ken Paxton shouldn't hire Brandon Kamak is, I don't need him. We shouldn't be spending money on him when we can't give raises to our employees. That was what you said, yeah?
That's what I said.
And Ken Paxton got upset and he said, so you're going to exercise veto powers over the budget for the agency?
He said that, yes.
That was his response to you, yes?
Yes, it was.
At the bottom, it says there's a chance of media exposure. Second the line from the bottom.
Yes.
You expressed you were worried about that, right?
I was worried for his sake, yes, and I warned him.
Go to the third page if you would, Eric. Again, we see on the third page the word inconclusive. The theory advanced by NP was inconclusive, yes?
I'm sorry, could you tell me, can you direct me to the part of the page you're looking at?
Yes, can you highlight that for the jurors?
Yes, it's about 3/4 of the way down. You see the word inconclusive? It says theory advanced by at the beginning of the line. Lower, Eric, right there. This theory, in about a third of the way down.
Yes,
Theory advanced by NP was inconclusive. Yes? You see that?
Give me, if I may have just a moment to read the paper copy.
Yeah, take your time.
Yes, I wrote that.
And toward the bottom of the page, and just leave it there, Eric, it says, I'm willing to hit the reset button and start fresh if they will produce docs, right?
Yes, I told him that.
You're 3 months into this referral, yes, and you're now telling your boss, I'm willing to hit the reset button, General Paxton.
That's
Yes?
what I told him on September the 26th, yes, after repeated requests for all the documents.
Turn the page if you would. Eric, give me the bottom half. You said, I told him this is a dangerous case. A dim DA or U.S. attorney could charge him with a play-for-pay scheme if they learned about the investigation, since Nate Paul is a campaign donor. Yes?
Yes, I wrote that.
Okay. You don't have any evidence that Nate Paul ever paid any type of bribe to Ken Paxton, do you?
I disagree with your statement.
Tell the ladies and gentlemen of the jury what evidence you have that Nate Paul paid Ken Paxton any type of bribe. Go.
I've read the evidence that was filed in response to the motion for summary judgment that your team filed. I've read...
Hold on a second. This is legal analysis based on what you've read? Is that right?
You asked me if I had any evidence. I'm trying to answer the question, sir.
No,
Yes.
You're analyzing what's evidence other people are offering in this case. On September 26, did you have any physical evidence, documentary evidence, eyewitness evidence, or circumstantial evidence that Ken Paxton had committed or been bribed by Nate Paul?
I had circumstantial evidence.
Anything else?
I had his behavior,
Anything else?
the campaign donation,
Anything else?
his absolute refusal to listen to common sense and reasoned legal positions. He wouldn't listen to anybody on the executive staff.
Anything else?
There's 4,000 pages filed in response to the summary judgment. There's stuff in there.
Did you have any of them?
I didn't have it on September 26. I know about it today.
The bottom portion of that bottom paragraph says, I gave him the scenario that NP, if indicted, could make up a story and throw him under the bus to the feds. That's what you told him, right?
I did.
You told him the risk was Nate Paul would manufacture false information that could harm Ken Paxton, yes?
That's the way I phrased it, yes.
That's what you said and that's what you wrote, yes?
Yes.
We get to September 30th or 29th and 30th, your head explodes, yes?
That's true. Figuratively speaking, I hope.
That's what you said that's what you said to the House Board of Managers,
I
right?
did, and I was extremely upset when I found out about the grand jury subpoenas, yes.
I'm going to show you what's marked as Exhibit AG 50. May I approach, Mr. President?
Thank you.
Mr. President, we move for admission of AG 50.
Any objection, Mr. Harden?
No objection.
Eric, if you would put that up
Admit
for me.
into evidence, please, AG 50.
You signed this, yes?
I did, yes.
It says, we have a good faith belief that the Attorney General is violating federal and/or state law. Yes?
Correct.
You had a good faith belief on October 1st, 2020. Yes?
Yes.
Did you bring any documentary evidence or physical evidence to the FBI?
No documents, no physical evidence.
And just to be clear, your testimony on direct was one of the reasons you thought Nate Paul had no credibility was he didn't give you any documentary evidence. True?
Based on his theory, there was nothing to back up his theory. Correct.
Yeah. And so it's fair to say if you had had documentary evidence of any crimes by Ken Paxton, you would have brought them to the FBI when you visited with them prior to this letter. True?
I disagree with you.
Oh, so you would have sat on it?
No.
If you had any documentary evidence of a crime by Ken Paxton, you would have brought it to the FBI. Yes?
No.
No, you wouldn't have?
No. This was an initial report by eyewitnesses. And it happened in a hurry.
I agree with that. How much of a hurry did it happen in?
Well, in one sense, it had gone on for 3 months, but what really took this to a crisis level was learning that Brandon Kamek, or Kamak, I don't know the exact pronunciation, was serving grand jury subpoenas that were designed to help Nate Paul in his civil litigation against his business adversaries.
You've testified about that. May I approach, Your Honor?
Thank you.
We move for admission of Exhibit AG 97, please.
When you have time to respond, Mr. Harden,
No objection, Your Honor.
admit AG Exhibit 97 into evidence.
From your office email, you forwarded grand jury subpoenas that were supposed to be secret to your counsel, Johnny Sutton, correct?
That's partially correct, yes.
And to be clear, you've never paid Johnny Sutton a dime, have you?
Not yet.
You have some type of pro bono deal with him?
No.
Who's paying for him?
We haven't agreed on a fee arrangement yet. We've agreed to discuss that in the future.
Let's let that sink in for a second. This man who's a former assistant U.S. attorney, he's with the Ashcroft law firm, I believe. It's in multiple states. He's represented you for 3 years and you haven't agreed on a fee arrangement yet? I want to make sure I understand.
That's right.
Haven't paid him anything?
Haven't paid him anything.
He's never sent you a bill?
No, sir.
Sounds like a great guy.
He is. And he's a former United States attorney, not an AUSA.
At some point in time, you get placed on investigative leave, true?
On October the 2nd, correct, by the Attorney General himself.
And by that point in time, there was still no file related to your investigation at the OAG, yes?
I'm sorry, I didn't hear the full question. Could you repeat?
There was no file at the time that you were placed on investigative leave in the OAG system related to the Nate Paul investigation, true?
I had a file with my personal notes on the case, but we had not officially opened an investigation file.
If you would, Mr. Arroyo, bring up Exhibit AG 1020, please. October 10 of 2020, these are your notes from a conversation with David Maxwell, correct?
Yes.
Blow up the bottom portion and highlight it, Mr. Arroyo. Highlight that bottom asterisk. Your plan, while you were still at the Office of the Attorney General you're on investigative leave on October 10, right?
That's true.
Your plan is to cook up bar complaints on Brandon Kamak, Michael Wynn, and Ken Paxton, isn't it?
That was not my plan.
It was David Maxwell's plan.
I write down what people say
Object
in my phone
non-responsive.
memos. I wrote that down.
Dane,
But he can't, pardon me, Your Honor, he
let's
can't.
back up. Let's slow down, let him finish his answer, then you can object. Go ahead.
Times at a premium, Mr. Penley. It was David Maxwell's plan as of October 10 of 2020 to cook up bar complaints against Brandon Kamak and Mike Wynn and Ken Paxton. Yes?
No, I don't agree with that. He said that. I wrote it down. That's what it means.
And you wrote it down because, well, why don't you tell these people what he actually said?
The best recollection, well, I have no independent recollection of these notes, so I wrote down the word cook up. We never did anything with it. We never even called the bar.
But the two of you talked about it, yes?
That comment was made on that date, and I wrote it down on October the 10th. Yes, I wrote that down.
And toward the top, it says, look at the defense fund, may need a grand jury subpoena, right?
Right.
That was part of your plan, wasn't it?
No, that was part of our conversation, and we were trying to find more links between Nate Paul and Ken Paxton.
If you would, Mr. Arroyo, Exhibit AG 1021. These are your notes. Let's work from the top. When did you write this?
Hang on just a second. I guess I don't have a paper copy. It was sometime after I was placed on investigative leave. I don't know the exact date.
At the top, it says Google KP's Defense Fund. Eric, if you could zoom in on that. See if we can access that document. Who's we, by the way?
Some of the whistleblowers. I can't name anybody other than myself.
You guys are trying to dig for dirt on Ken Paxton, right?
We're trying to find evidence to defend ourselves because we were being unjustly treated.
Next paragraph, Mr. Arroyo. At the top, you write, Missy told him he could sign the contract and hire outside counsel. Yes?
I wrote that down, yes.
That's Missy Carey, the Chief of Staff of the Office of Attorney General, yes?
That's correct.
And your notes, your recollections from this meeting, were that you were all discussing it, and the Chief of Staff said, Ken, you can sign that contract, yes?
Well, I don't know this was from a meeting. I believe it was from a phone call.
Let's go to the bottom two lines on that page, if you would, Mr. Arroyo. The bottom you wrote, KP must be indicted by spring break. You wrote that, right?
Yes.
That was what you wanted, wasn't it?
At that point, yes, because I believed he'd broken the law.
Of what year?
I'm sorry?
Of what year?
The law of what year?
Ask the witness.
Mr. Hardin, redirect.
Thank you, Your Honor. Oh, thank you. Thanks a lot. Mr. Penley, I'll just take a few minutes with you. Just a few things I want to mention real quickly. But what is your testimony as to whether or not at the time all of this was happening, you had seen the referral that is called the second referral And if we could, put up the front page of AG Exhibit 124, please, Stacy. It's okay. Thanks a lot. Now, Stacy, if we could, put the date, isolate the date there. So September the 23rd, correct?
Correct.
That you're really only, everything blew up, we can all agree, can we not, on September the 30th, with y'all going to the FBI and so?
I'd say September 29th, the day before, with the first grand jury subpoena being reported.
Okay, but you went to the FBI on what date?
On the 30th.
All right. Now, this is just 1 week before that, is my point, is it not?
Yes, sir.
And were you ever, during any of the time this was going on, were you informed that after filing the complaint back in June on the referral, that now after things are, you've been looking at one referral?
Yes.
Is your testimony throughout this case, y'all were only concerned with one referral?
Right. I only knew of one referral all the way to the point when I got put on investigative leave.
All right. Have you since reviewed, after this was all over, after you were terminated, well, back up, had you seen this referral number 2 from this gentleman before you were terminated?
I think I saw it between the time I was put on leave and terminated, which was a month. I think I saw it in between that time.
And at the time, now did that lessen your view of, or change your view of Mr. Paul, or did it increase the view you already had reached?
It increased my anger at the Attorney General.
All right, hold on a second.
For doing all this.
Hold on a second. I want to move you now to Stacy Bates Stamp. I think it's Bates Stamp 2443, please, Stacy. Now, you've heard on cross, you've been asked questions about when y'all met with the investigative committee that you weren't under oath, right?
Yes, I recall that.
I'm going to look at this. Does this page show? All right. Do you see whether or not Mr. Paul once again had a choice of whether or not to swear to the allegations he was making?
Yes, I know that on both referral number 1 and number 2, those forms from Travis County have a line for a notary signature and a swearing that everything is true.
Now, what is your opinion as to whether when he goes to the district attorney's office to file a complaint and has a chance to make his allegations, did he swear to those allegations?
He did not swear to either complaint in referral 1 or referral 2.
And when he didn't swear to the complaint, did you, once you found out about it, while you were, you say, on leave before you were officially terminated, did you look at the allegations this guy was making this time?
I looked at the allegations. With that combined with everything else that had occurred, made me look in a highly skeptical way at his claims.
Well, let me ask you this. Did you look at this referral number 2 and see that now he wants a federal bankruptcy judge investigated?
Right. That makes 2 federal judges he wants the state of Texas to investigate, even though we told him he needed to go to the United States Department of Justice Inspector General's office to take these claims.
And to take him seriously.
He wanted us to take him seriously, I agree.
Go to Bates Stamp if you can, Stacy, 124. Or that's the exhibit, excuse me. Bates Stamp 2445. I want you to look at how many people now does he want an investigation of. For instance, look at on page 2445, let's scroll down. Will you just read out the names of the people he now wants y'all to investigate in addition to the people he wanted you to investigate in the original referral?
Yes, sir. Brian Hardiman,
Slow down. Do you know who Brian Hardiman is, one way or the other?
I do not.
Next one.
Will Hardiman.
Do you know who he is?
I've read that's Brian Hardiman's son.
Do you know who Christopher Dobson is?
No.
Are you aware that's opposing counsel in the cases he's in litigation with?
No, but I'm not surprised.
Stephen Benish, do you know who that is?
I do not.
Do you know who Jason Cohen is?
I do not.
Do you know who Mark Riley is?
I don't.
Do you know that Mark Riley is engaged in a civil lawsuit with him?
One moment, Counselor.
Yes,
Can
sir.
we take out that information, please, on addresses?
Pardon me?
Just very briefly, Mr.
Yes.
President, assuming facts not in evidence,
I didn't hear what you said, I'm sorry.
I'm saying, assuming facts not in evidence, Mr. Hardin is saying that these people are certain things and the witness has no knowledge of it.
Sustained.
Do you know Jason Bain is?
I don't know him.
Do you know whether Tony M. Davis is a federal bankruptcy judge?
Yes, I understand that he is a United States bankruptcy judge in the Western District of Texas in Austin.
And do you know who Ray Chester is?
He is the trustee for the Mitty Foundation, which is involved in a lawsuit with Nepal.
Is Ray Chester a trustee or is he opposing counsel representing the Mitty Foundation?
My understanding is he's an attorney, but he's also the trustee represented by counsel.
Do you know who Mr. Milligan is? Gregory Milligan.
I believe he's an attorney in Austin, somehow involved in that litigation.
At the end of the day, when you read this particular referral, is there any way on God's green earth you would ever want to support a criminal investigation based on this guy?
Absolutely not.
I have no further questions.
Recross, Mr. Little.
No recross, Mr. President. May I have a moment to collect all my goods from up there?
You may.
Are these your notes down here?
Mr. Hard, Mr. Little, may this witness be excused?
I would hope so, Your Honor.
Subject to potential recall, of course, but yes.
Yes. You may step down. Thank you. I'm going to take all those, leave those here for us.
Thank you, Lieutenant.
Yep. Thank you, sir. Who's the next witness? Yes. Hit that, we can't hear you. Here you go.
Here we go. Mr. President, the House Board of Managers calls Catherine Missy Carey.
Bailiff, will you bring in Missy Carey? Would you raise your right hand? Take the following oath. I do solemnly swear that I or affirm that the evidence I give upon this hearing by the Senate of Texas of impeachment charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Please be seated. Counsel, will you give your name for the record?
My name is Therese Boos.
You may begin.
Thank you, Mr. President. Good afternoon.
Good afternoon.
Would you please state your full
Hold
name?
on. Both of you are going to have to get much closer to the mic and speak up a little bit more. Yeah. No, it's the acoustics are not
Yes,
great
sir.
in here.
Is that better?
I can hear you. It's a big room. Can you hear me?
Yes, ma'am.
All right. Would you please state your full name?
My name is Catherine Minter Carey, although I sometimes go by Missy.
Is that a name your parents gave you?
It's a nickname. My sister and I were Missy and Prissy growing up, and, I got the better end of that deal.
So which name do you go by?
I think everyone here would know me by Missy.
All right. Okay, if I call you Missy.
It is.
All right, Missy. Where did you grow up?
I grew up here in Austin.
And what did your mom do?
She was a school teacher and a stay-home mom.
How about your dad?
My father's an attorney.
And where did he work?
Actually, his first job was he was an assistant attorney general at the attorney general's office from 1965 when I was born to 1971. And then he had private practice in a law firm here in Austin.
Was he a role model for you?
He is a role model for me, yes.
See why you became a lawyer?
He is.
How about the Attorney General's office?
It just, when I was a kid, he would take me up there. I was probably kindergarten or first grade, and it was like the scene from Mad Men, if you know the TV show. It was a cool place, and it was what I always wanted to be.
So where did you go for undergrad?
I started at Hollins College, which is a girls' school in Virginia, and then I transferred to Texas A&M, where I graduated with
What's
a
your degree in?
political science.
Where'd you go after that?
I went to law school at St. Mary's in San Antonio.
And were you licensed to practice law?
I am. I'm licensed in Texas in 1990.
After you got your license, where did you go to work?
My first job was here at the General Land Office. I was a staff. First, I started out because I didn't have my bar results, and I learned quick that the Appropriations Act says you have to have a license to be a lawyer. So I started actually as a legal secretary or law clerk, and then when I got my results, I became a staff attorney there for 5 years.
And when you got promoted to staff attorney, what kind of things were you handling?
I did employment law. I wrote legislation. I worked on the Open Beaches Act, the Oil Spill Response Act. I did a little bit of collections for the Permanent School Fund. Did different things like that.
At the end of your 5 years, where did you move to?
I moved for the first time to the Office of the Attorney General
Okay. And which department were you assigned to work in?
the Administrative Law Division.
And what kind of things did you handle?
So part of the time I was a litigator in administrative law, represented the state in court. The other duties were general counsel to various state agencies that didn't have their own general counsels. I did open records, open meetings. I drafted rules, tried cases about the Administrative Procedures Act, did some employment law.
Sounds like all kinds of things.
Kind of a division that does a little bit of everything government-oriented.
Did you leave the Attorney General's office?
I did. I left the Attorney General's office for a while in 1997, and I was conscripted, so to speak, to work at the Texas Lottery Commission for Harriet Myers, Anthony Sadbury, and Judge Hill, John Hill, to work on a matter with the executive director at the time that was kind of well known in the press.
Okay.
So
Was there a scandal?
there was.
And did it all have to get cleaned up?
It did.
And did you assist with that?
I did.
All right. After that work got done, where did you go?
After that work got done, I was asked by incoming Attorney General, now Senator John Cornyn, to come and be the Attorney General's office's public information coordinator. So I came back to the Attorney General's office in 1999, and I did the coordinator position for a year, and then I was given the division chief of the Open Records Division next, and I think I held that position about 6 or 7 years.
And at the end of that, where did you go?
I was promoted to the general counsel position for the Office of the Attorney General, think in 2006, I was the agency's general counsel.
And after that?
After that, I was promoted by Governor Abbott when he was still Attorney General to be the deputy for administration for the Office of the Attorney General, and I remained in that position when General Paxton came in and did the same basic job for both of them.
Tell us how many attorney generals you've worked for.
As Attorney General, I've worked for 4, and then John Hill at the Lottery Commission.
Okay.
So 5.
Tell us the names.
So Dan Morales, John Cornyn, Greg Abbott, Ken Paxton, Attorney General Hill when he was on the Lottery Commission. And I also worked at the land office for Gary Morrow, who was a statewide elected official.
In 2014, when Ken Paxton became the Attorney General, did you receive a promotion?
I did.
And what were you promoted to?
I was the first female chief of staff of the Office of the Attorney General, and the first person to work their way all the way up from a line lawyer to a position that high in the agency.
And who did you report to in that position?
I reported to Jeff Mateer, who was the first assistant. Well, actually, probably it was Chip Roy first. I can't remember. It was the first assistant, whichever one was there first.
And eventually to Jeff Mateer as
Indeed.
first assistant?
I think Jeff was their chief of staff, yes.
Okay. May I have Exhibit 553, please? It's not in evidence. It was used, I think, with the very first witness. And I'll offer it into evidence. It's an organizational chart.
Any objection?
No objection, Your Honor.
And I don't have a copy, but what's the number?
It's 553.
553 into evidence. In the future, if you all can give us a copy. Thank you.
Can you see the chart, 553?
I can.
Okay. And what year is this chart reflecting?
This chart, even though it's dated September 2020, I think reflects the organization as of September of 2019.
Okay. And have the names changed a little bit during the time that you were there? I'm interested actually in the divisions and the deputies, the slots. Can you, looking at the far left of the line of executives, can you tell us, as Chief of Staff, during the period of time that you were working with Ken Paxton as your assistant, as your Attorney General? Start at the left, if you would.
So there's a different org chart that's now come up on the screen. This organizational chart is the chart from 2019, before September 1st, 2019. And I'm happy to answer the question. I'm just not sure which chart you want me to answer the question for.
Are we on 553? 553. 553. I'm interested in the divisions.
I understand.
Can you
Oh, which chart are you interested in the divisions on? There's 2 organizational charts, and it's different, actually.
how about the one that we're looking at right now? Does that help?
That helps.
Yes?
Yes.
All right. Let's start at the far left of the chart.
Okay.
And can you tell us which divisions you supervised and spent the most time with?
The first assistant supervised all the deputies. However, Mr. Starr and I sort of split the deputies by areas of our expertise to assist Jeff in his management of the deputies. So for me, I was most involved with the Deputy Attorney General for Child Support and the 440 Director, the Chief Information Officer, which is the IT department, the Deputy for Administration, the Deputy Attorney General for Criminal Justice, the Director of Law Enforcement, and if you could shift it over a little bit. And that would be all there. And then if you look above, directly reporting to me was the agency's Public Information Coordinator, who I oversaw, and then I also helped the first assistant with the ombudsperson and the internal auditor.
When you retired, how many years had you spent with the Attorney General's office?
Just the Attorney General's office, somewhere over 20.
Okay.
25, probably. 20, well, probably 20.
And during the time that you were there, would you say you developed certain areas of expertise?
I did over my career develop certain areas of expertise, yes.
And those particular areas, do you actually teach? You teach other people about them?
I have taught other people in the past, yes, about my areas of expertise.
What kind of places have you taught at?
I mean, I've taught at CLEs, I've taught at the National Association of Attorneys General. I was one of their instructor faculty. I've taught about how to run an Attorney General's office, how to fund an Attorney General's office, what do Attorney Generals do. I've consulted with other Attorney Generals across the country about their Attorney General's offices. I've taught ethics. I've taught contracting. I've taught administrative law. I've taught open records many times, open meetings, administrative law in general.
And how about writing? Have you published any publications?
I have. I've published law review articles and other writings, both about employment law, procurement law, administrative law. I'm board certified in administrative law.
I'd like to go forward to 2018, if you would.
All right.
Okay. What building were you officing in at that time?
My office in 2018 was in the Price Daniel building, which is attached to the Supreme Court on this side of the street.
What floor?
The 8th floor.
And who officed around you?
My office was directly next to the first assistant's with his assistant in between us. And on the other side was the conference room and then the Attorney General.
So would it be fair to say that the people around you were the executive team?
Correct.
Was it all of the executive team or part of them?
It was part of the executive team. For example, the Child Support Division has its own building out on Old Wharf, and the Child Support 40 director always had an office in each place. The director of law enforcement and the head prosecutor also had 2 offices, as did the director of IT. But it was intended to be the executive staff on the 8th floor.
So in 2018, can you tell us a little bit about the quality of the executives that were around you? Who were they and what did you think of them?
Well, I mean...
Your Honor, objection relevance. It doesn't matter what she thinks of them. It has nothing to do with this.
Sustained.
Can you tell us, please, the people that worked with you, did they mirror the policy choices of Attorney General Paxton?
Your Honor, again, relevance. Object.
Would overrule this time.
They did. The executive team was created in order to further General Paxton or any Attorney General's agenda and desires of where they want the office to go, and they did so.
And during the period from 2018 up to 2020, were you aware of how they were perceived by people outside of the office, other professionals?
Objection, Your Honor. That calls for speculation. How can she know what people outside the office thought about these people?
I can qualify.
Sustained.
Are you familiar with how the executive group within your office was perceived by people outside of the office? For example, other professionals in Texas and even outside of Texas?
Objection, Your Honor. Personal knowledge, she doesn't have it, and to the extent she has any, it would be hearsay.
Sustained.
Do you know what the general opinion was of the office from 2018 to 2020?
Objection again, Your Honor. The general opinion of who? There's almost 30 million Texans. There could be 30 million opinions.
Sustained.
Did the executive team meet regularly with Jim Mateer?
With Jeff Mateer, yes.
Sorry. And at those meetings, would you all catch up on what was going on with each other's departments?
We had a Thursday executive meeting that included, at times, General Paxton and Mr. Mateer and the deputies, and we caught each other up on what was going on, yes.
Can you tell us what General Paxton's involvement with the day-to-day operation of the office was?
His involvement was similar to most other attorneys general. Most attorneys general set the high-level policy and high-level direction of where they want the executive staff to go, and then depend on the executive staff to complete those tasks and to follow that direction.
So, Missy, you had worked in the office for a very long time at that point. As you looked around you at the people that you were working with, how would you describe them?
Objection, Your Honor. Vague and irrelevant.
Sustained.
What kind of group were they?
Again, I have no idea what that means. What kind of group were they? It could be anything. Vague.
Could you be more specific? Thank you.
Yes. Was there a description that you used for the people that you were working with? Did you call them something?
I'm sorry to interrupt again, Your Honor. It's the same objection.
Have to sustain.
Of all of the people that you worked with at the Attorney General's office, and again, I know they're like children, right? We don't like to say which ones are our favorite, but as a group, can you quantify them for us from 2018 to 2020?
Your Honor, I hate to slow this down, but that question is vague and, as best I can tell, irrelevant.
Sustained.
Describe your office for us in 2018.
Is she, again, vague? Is she talking about the building? I'm not sure what she's talking about, vague.
Yes, Counselor, can you be very specific?
Yes. Can you tell me a little bit about the people who worked around you from 2018 to 2020, your executive team?
It's a compound question, objection. She's asking about multiple people. We don't know who she's talking about, but to the extent it's more than one, it's compound.
I can take them one by one. If counsel wants me to do that, we can do that.
You're on the clock. Yes, I want you to do that. Ask a specific question.
Okay. Sustain. Be specific.
Did you have an opinion about the people that you were working with, your executive team, during that time period?
Yes.
Tell us what that opinion was.
Objection, Your Honor. Vague. Which person is she referring to?
I'm referring to the entire executive team that we've talked about.
Yeah, we
And
can.
I'm sorry to do this, but she can ask, what's your opinion of material? To the extent that's even relevant, probably not, but this is very vague, and to the extent it's not vague, it's compound.
I'm going to overrule. You can ask the question. You can answer what your opinion was of the overall team.
You can answer the question.
My opinion of the overall executive team was that they were incredibly professional. They were committed to General Paxton's agenda, and it was a credible set of legal minds.
Was part of your responsibilities working with and supervising the security detail group?
Yes and no. I did not supervise the security detail because they work for the Department of Public Safety, but I did liaison with the security detail as one of their points of contact, myself and Jeff Mateer.
Okay. How about the scheduler?
The scheduler did not report to me, reported to Jeff, but I did help at times with questions and things with the schedule.
I want to talk with you specifically about spring of 2018, okay?
Yes.
All right. Was there an incident that caused you some concern?
Yes.
And I want to talk about that. Can you tell us where you were when it happened?
I believe you're referring to an incident at the Galaxy Cafe.
I am.
Spring of 2018, I was at the Galaxy Cafe on West Lynn eating lunch by myself. They have very small tables that sit 2 by 2, very close to the person who's sitting next to you. I was alone eating lunch, and there was a man and a woman sitting to the table directly next to me, probably within 3 feet away. And they were having a conversation. And the woman of the group was sharing what I perceived to be very
Objection.
personal.
I'm sorry. She's about to repeat hearsay. I object to that.
Sustained.
As you sat and listened to the conversation, did you overhear some information that you felt was inappropriate?
This question calls for speculation and also hearsay. I object.
Sustained.
As you sat and listened to the conversation, how did you feel?
Objection, relevance. Doesn't matter how she felt. I mean, that has nothing to do with this case.
Sustained.
As you sat and listened to the conversation, did you decide to do something?
Objection, vague. I'm not sure what that means, Your Honor.
Will overrule.
What did you do?
After listening to the conversation, I took a photograph of this person and took it back directly to Attorney General Paxton.
And why did you do that?
Excuse me, can you move closer to the mic?
Yes.
Thank you, Ms. Carey.
And why did you do that?
Because I felt the conversation was.
Objection, hearsay.
I'm not asking for hearsay. I'm asking what her concern was.
That's not what the question was, Your Honor.
I asked her,
Would you repeat the question?
yes, you took a picture of the woman. Why did you do that?
I wanted to talk to General Paxton about it, what I saw.
Is security of the Attorney General something that you as an employee were very concerned with?
Always.
Was the conversation that you overheard causing you concern about safety for the Attorney General?
No.
What was it causing you concern about?
Objection, she hasn't said that she was caused concern. I mean, it assumes that she was concerned, and she hasn't told us that yet.
Sustained, you can ask that question.
Were you concerned?
Yes.
What were you concerned about?
The level of personal detail being shared in a public space.
And was it directed to the Attorney General, Ken Paxton?
No.
Who was it directed to?
It was directed to a man who I did not recognize at her lunch table.
Okay. The woman that was speaking, did you recognize her?
No.
Did you do anything further before you left the restaurant?
No.
Did you monitor the woman as she was leaving the restaurant?
Objection, leading.
Sustained.
What did you do?
She's already said she did nothing else, Your Honor. Asked and answered.
Can you rephrase that a little bit?
I can. Before you left the restaurant, did you try to get any additional information about the woman?
I looked at the car she was driving when we were leaving at the same time.
And what kind of information did you get about the car?
I noticed the kind of car it was, the color, and that it was a car purchased in San Antonio.
Okay. You had the picture in your phone, you had the car information. What did you do with that?
I waited for a time when I could talk to General Paxton privately, and I talked to him privately about what I'd witnessed.
Okay. Tell us what you told him.
Objection, hearsay.
It's not offered for the truth of the matter asserted, Mr. President. It's to show the effect on this witness and the actions that she took as a result of it.
Overruled.
What did you tell General Paxton about what you heard?
Basically what I just told the court, and I asked him if he knew who she was.
What information did you relay to him about what you had heard?
I relayed to him that I was sitting at lunch alone in the Galaxy Cafe, and I overheard loudly a conversation between two people, and that the details that were provided by this person were surprising to me and of concern, and I wanted him to know about it.
Specifically, what details were you concerned about?
This is hearsay, Your Honor. You've already ruled on that.
Sustained.
And I'm not offering it for the truth of the matter asserted. I'm trying to show why she's doing what she's doing.
If it's not offered for the truth, then it's irrelevant.
Sustained.
When you talked with General Paxton, how did he respond?
He told me that I had taken a picture of his realtor who was trying to sell his condo on Enfield, and that he would talk to her.
Did you believe that?
Absolutely.
Was he concerned that someone was talking about his personal business in a restaurant out loud?
No.
Did you believe him when he said it was his realtor?
Yes.
Objection asked and answered.
Overruled.
Did he provide a name for that person?
No, he did not.
All right, let's come forward now to May of 2018. Did you have an occasion to go to an official function in San Antonio?
Yes.
And did you see someone there that you recognized?
Yes.
And who was it that you recognized?
Same lady I'd seen in Galaxy Cafe.
Okay. A realtor at an official function? What kind of function were you at?
Was at a National Association of Attorney General's reception, a happy hour, cocktail hour.
Okay. Did you get the name of that person?
He was wearing a name tag.
And what was the name?
Laura Olson.
Okay. During the course of the spring and summer of 2018, did you come to learn what the relationship was between Laura Olson and the Attorney General?
I did.
Objection, Your Honor. I'd like to lay a predicate for that. Otherwise, it's based on hearsay.
Sustained.
How did you come to learn about the relationship?
Attorney General told me about it. I was also told by the security detail and the travel aides.
And did you confirm that it was the named Laura Olson, same person?
I did.
How did that make you feel about him telling you that she was a realtor?
Surprised.
That he had lied to you?
Yes.
May I have House Exhibit 623, please? Would offer State's Exhibit 623 into evidence. Mr. President, it's a public record.
Your Honor,
Do we need to redact any of this?
I would think so, Your Honor. This is like a speeding ticket or something?
The information that's going to be put up is going to be redacted. It has been redacted.
Not my copy.
Yeah, nor on mine.
I don't think we should be using this private personal information about anybody talked about in this trial.
The hard copy will be redacted. What's going to be shown has been redacted.
I don't know what they're going to show.
Oh, can you show us the redacted copy? Because ours is not redacted, nor counsel. We'll break in 15 minutes. We're going to continue to the top of the hour.
Thank you, Jim.
I'm sorry, we're not, I said we're going to break in 15 minutes at the top of the hour. You may stretch your legs if you like, senators, but we're going till the top of the hour.
If I may, I'm going to move on and we'll come back to this exhibit.
Okay, we'll come back to that exhibit. Continue.
During the spring and summer of 2018, were there some things that were happening within the office concerning Laura Olson that you were having to deal with?
Yes.
Specifically, were there problems with morale?
Yes.
In which areas of the office were you having difficulty?
Travel aids, security detail, Mr. Mateer.
How about the scheduler?
To the witness, can you repeat that? We couldn't hear you clearly.
The travel aids, the security detail, and Mr. Mateer was my answer, Your Honor.
Let's talk about the travel detail. What kind of problems were you having to deal with?
The travel detail was calling about the hours they were working, the places they were being required to go, and they were concerned about the general's behavior.
Okay. How about the bag man? What is a bag man?
It's a travel aid, and the travel aid is the employee at the Office of the Attorney General that's generally assigned to the Attorney General, does things like make sure they're on time, has their speeches, make sure you get to the venue on time, keeps time, sort of time management, holds on to those it's a close aid,
Were there
personal aid.
Were there problems with the bag man as well?
Yes.
What kind of problems?
Complaining about the hours worked that weren't state business, expressing those concerns to me because I approved their leave or required them to take particular kinds of leave for non-state business events.
What kind of complaints were coming about the hours?
Too long hours, no vacation, odd hours.
Were there complaints about security concerns?
Your Honor, I'm sorry to interrupt. We're talking about 2018.
We are?
Some complaints in the office from 2018 that has nothing to do with any of the articles of impeachment, I would object to be irrelevant.
Overruled.
Complaints concerning security. What were the worries?
Similar concerns.
Which were what?
Hours worked, non-state business, disorganization, and changes to the schedule.
Issues concerning not state business. What kind of things?
I mean, I think the affair was one of the concerns that was not state business. So were some of the different switches in the schedule between campaign events and state business.
Who is J.B. Skis?
He was General Paxton's travel aide at that time.
And for the court reporter, it's S-K-E-E-S. Is that correct?
That's correct.
All right. And what kind of problems did you have with him, if any?
I personally didn't have problems with JB. JB quit unexpectedly and refused to tell me or Mr. Mateer why.
You ever had that happen before?
I have not.
Were there issues with the Attorney General's wife that you were having to deal with as well?
At some point in time, Mrs. Paxton was calling the office, asking about the schedule or asking where he was, and the staff was uncomfortable sometimes answering those questions, and they were complaining about that.
Why would they be uncomfortable?
Objection, speculation.
Sustained.
Do you know what caused them to be uncomfortable?
Only what I was told.
And what was your understanding?
This question is going to be relating hearsay, which you just set it up as hearsay, so I object hearsay.
Sustained.
With a problem like that, with the problems that you were having concerning morale, what did you do?
In 2018,
Yes.
I talked to Mr. Mateer, He and I talked about it. I also had a conversation with General Paxton directly by myself about it.
Okay. Let's stop and talk about that. Do you recall when that was?
I cannot be precise, no.
Do you recall what time of year it was?
It would have been the summer of 2018
All right. Where did you have that conversation?
in my office.
Okay. And what did you talk about?
Objection. To the extent she's going to relate what she said, that would be hearsay.
She's here for cross-examination.
Sustained.
What was the topic of conversation?
Objection asked and answered. She already told us what the topic was.
Overruled.
What was the topic?
The topic was the ethical implications of a secret affair.
Were you able to relay your concerns?
Yes.
Did he confirm that he, in fact, was having an extramarital affair?
Yes.
And did he tell you that that was with Laura Olson?
No.
Not at that time?
No.
All right. What was his attitude when you told him that things were not good within the office because of that?
He was contrite, and he listened to what I had to say very carefully.
Did you get the feeling that he thought it was none of your business?
Maybe. But we had a good conversation,
Okay.
a productive conversation.
Were you able to help him understand why it was affecting the life of the office itself?
I tried to do that.
How did you do that?
We talked about what had happened to previous public officials that I had counseled in similar situations. We talked about previous public officials and what happened to them in similar situations. We talked about the risk involved in secrets of this magnitude that began to bleed over into the work of the Office of the Attorney General.
What kind of risks are there?
I mean, there's ethical risks, there's political risks, there's legal risks.
What kind of legal?
These things can open one up to bribery, misuse of office, misuse of state time, things like that.
How did he receive that information?
Well,
Okay. Did you make a request of him to tell his wife, Angela?
I did.
How did that conversation end?
Contemplatively, and then he left my office.
Were voices ever raised during this conversation?
Not in this conversation, no.
All right. Based on what you know of him and your experience working with him, how does Attorney General Paxton react to confrontation?
He's generally very patient, and he listens well, and he takes in information. So I would say he reacts well to confrontation.
Let's come forward to October of 2018. Was there an occasion that you went to the campaign headquarters?
I did.
Right.
I think that was actually September of 2018.
Okay. And
Precise.
who is present at that time?
Gordon Berry, Jeff Mateer, Brantley Starr, Ben Williams, Mark Rylander, I think, perhaps, myself. And I'm not sure, I could be leaving somebody out, but that's the ones that stand out.
Okay. And what was the occasion?
We were invited to meet with General Paxton and Senator Paxton to talk about this matter,
This matter being what?
the affair.
Okay. Would it be fair to say that General Paxton confessed the affair to all of you?
I think that'd be a fair characterization.
Okay. Did he apologize to all of you as a group?
Did.
Okay. Describe that experience very briefly, if you would, please.
An uncomfortable experience. It's an experience I had not had before in my life. Somber. Be a word I'd use.
How did General Paxton's wife take it? How was she responding?
She was sad and embarrassed, I believe. That was my impression.
Was she crying?
She was.
Right? When you saw that, what did you do?
My heart broke for her.
And what did you do?
After the meeting had concluded, I think I hugged her, and I think I told her that I was sorry this had happened to her.
Okay. What happened after that?
We broke up and went home. Went back to work.
In September of 2018, after that meeting, did you believe that Laura Olson was out of his life for good?
Again, at that point, I didn't know her name, but I thought that this type of behavior was out of his life for good, yes.
Let's talk about August 1st of 2019, coming forward now in time. Was there a change in your duties?
Yes.
What happened?
Judge Starr was being promoted to the federal bench, so there was a vacancy in the deputy first assistant position, which was equal to mine, both reporting to Jeff and helping manage the deputies in the way I described in the exhibit. I was told that that was going to change, and when the new deputy first assistant came in, who was Ryan Bangert, that my duties would be changed and I would be reporting only directly to Mr. Mateer.
Okay. Did you receive an explanation as to why those changes were being made?
It was my understanding that those changes were being made at the general's request because I had said no to him too many times, is what I was led to believe.
Let's talk about that. What kind of things would you say?
Counselor, excuse me. The jurors have been here for 2 hours. Can we break? Fine.
Certainly.
Members, come back at 3:20. 20-minute break.
Stay right here, sir?
You can stay. Bailiff, will you bring the witness back, please? You have the witness.
Thank you, Mr. President. Are you ready, Lacey?
I am, can you hear me now? Okay, there we go.
I can hear you.
Okay.
Do you have an exhibit in front of you, Lacey?
I do not have an exhibit in front of me. And the screen is blank.
Defense has it, 623.
You did. I ignored you. Whatever.
Missy, can you give me the number on there, please?
Exhibit number 623.
Do you recognize the person on there?
I recognize the name, yes.
Do you recognize the photograph that's on that exhibit?
I recognize the photograph to be Ms. Laura Olson, yes.
Is that the person you saw at the Galaxy Cafe?
To the best of my belief, yes.
Is that the person that you know to have been having an affair with Ken Paxton?
Yes.
All right. Your Honor, this time I would offer an evidence number 623.
I don't have a copy of the redacted one, or do we now? I'm not sure if we, is it 4 pages? Yes, Your Honor. It's been the second to redacted on. Okay, thank you. Is there any objection?
No, Your Honor.
Admit exhibit number 623 into evidence.
Thank you. The photograph that you took in your phone of the woman at the Galaxy that we now know to be Laura Olson, what did you do with it?
I deleted the photograph at the general's request.
Did he ask you to do that when you first talked with him about the woman?
He did.
When he told her it was his realtor?
He did.
All right. I want to come forward now to the summer of 2019. Were there continuing to be problems within the office, the type that we had talked about already?
Those problems began again, yes.
Okay. Who were you hearing from? I'm not asking you what they told you, but what people within the office were talking with you?
Travel aides, Mr. Mateer, the security detail.
Were there problems that were happening outside of Austin?
Yes.
All right. Was there a further conversation that you had with Ken Paxton concerning the affair?
Yes.
Did you learn that the affair was continuing?
From
Objection, speculation, Your Honor.
Sustained.
And thank you. Did you learn that it was continuing?
Objection, speculation, Your Honor, and anything that she would have
Been ruled.
learned. Let me finish,
It's
please.
been ruled.
Excuse me.
Anything
Sustained.
she might have learned, would it be based on hearsay or speculation?
Sustained.
Did you have a conversation with Ken Paxton during that time period?
I did.
That'd be the summer of 2019?
Correct.
Let's talk about that conversation. Where did it happen?
In my office on the 8th floor.
Did you initiate it or did he?
He did.
And what did you all talk about?
We talked about Ms. Olson again.
And did you learn that the affair was continuing?
Yes,
Did he tell you that?
yes.
How did he tell you that? What kind of voice was he using?
He was frantically upset.
At who?
I think he was frustrated, and he wanted to express to me that he was frustrated with me and that I didn't understand what he was trying to tell me. And he was trying to tell me, he came in and said he was frustrated and that I didn't understand. He still loved Mrs. Olson, and he wanted to work it out with me.
What did you take that to mean?
For me to be more accommodating as far as the security detail, the travel aids, any of his requests.
So in your very first conversation, when he first told you he was having an affair, had you given him some advice, some professional advice?
I did. I gave him ethics advice.
And what was that advice?
The ethics advice in 2018 was that when you try to keep things secret and you're a statewide elected official who's running for office, that it could be both ethically, legally, and morally challenging, and that it was beginning to bleed over into the office.
And is that what you were seeing?
Yes.
All right. Your second conversation in the summer of 2019, did you give him some similar advice?
I gave him the identical advice.
All right. Did you tell him that he needed to get his life in order so that the office could get back on track?
I did.
And leading and hearsay.
Sustained.
What did you tell him he should do?
Objection, hearsay.
It's not hearsay, Your Honor. She's the declarant, and Mr. Busby knows she's available for cross. He can have time with her when I'm
Overruled.
done. You can answer.
I told General Paxton quite bluntly that it wasn't my business who he was sleeping with, but that when things boiled over into the office and into the state work, that it had become my business, and that I was having concerns about how the time and the effort of the travel aides, the security detail, and myself was being spent.
And I want you to tell us what his demeanor was when you told him that.
He was angry with me.
How could you tell?
He raised his voice loud enough that it was heard outside my office, even though the door was shut. He was, his hands were waving. He was red in the face. He was upset with me.
How did that conversation end?
He stormed off out of my office. He ended the conversation.
Now, you mentioned that your duties had changed. Were you still managing all those different departments?
I was until September 1st of 2019. So at that time of the conversation, was still helping manage those departments.
Okay. I want to talk a little bit now about outside counsel contracts. Is that an area of your expertise?
It is. When I was the general counsel of the Office of the Attorney General, it was my duty to process those, read them, approve them. I wrote the administrative rules regarding those contracts. I wrote the contract form, so I'm very familiar with the outside counsel contract process.
In your time at the Attorney General's office, have you approved and actually evaluated a few or many of those contracts?
Thousands of those contracts.
All right, so you're very familiar with them.
I am.
Do people come and talk to you and ask questions about outside counsel contracts?
They do.
In fact, they ask you about a lot of things in that office, don't they?
They do.
All right. All right, I want to talk a little bit about the rules, because there are rules within the Office of Attorney General, are there not, for approving those contracts?
There's a procedure that's published on the agency's website, and there's also the administrative code, Texas Administrative Code 1 TAC, Chapter 57. It's related to outside counsel.
Let's talk just a minute about the procedure. Within the Office of Attorney General, when one of those contracts is being drafted up, what's the approval process, very quickly?
For a contract for the Office of Attorney General.
Yes.
Those contracts are generally initiated by the deputy that's interested in having the contract. It's routed through a sort of an audit procedure, which is called the Executive Approval Memo. Down in the General Counsel Division, the form is filled out with the pertinent information. There's a contract number that's established. It's put into a computer system, and it's reviewed for the requirements of the Appropriations Act and the rules.
Is there a requirement that there's some kind of finding concerning the best interest of the state?
I think what you're referring to is in the Appropriations Act, Article 9, Section 1601A. There's a requirement before you can spend appropriated funds on an outside counsel for the state. A determination needs to be sent in writing to the controller that the contract is in the best interest of the state and that can be paid.
Is there also a requirement that the attorney who's being hired be qualified
There is.
for the particular job at hand?
There is.
And do you have to have money allotted for the contract?
Yes, it helps.
That's part of
it
the
helps to have
procedure?
money allotted for the contract, yes.
All right. So you
Unless
have
the
to,
attorney's working for free, but
the forms that were used within the Attorney General's office during this time period, are they the forms that you designed?
they are.
And the procedure where everyone has to sign off, all the different levels, was that something that you worked up?
Something I was involved in working up, yes.
Okay. And it's computerized now. Was it always that way?
It was not. It used to be in paper with a routing sheet on top.
All right. Are applications for those types of contracts given identifying numbers when they're going through the process?
They are.
And is that important?
It's an important tracking mechanism to track the contract and that it's in the system and that it's approved, and it also allows the accounting division and the budget division to know which funds to pay that contract, which funds to direct the controller to pay the contract out of.
Missy, can you tell us when you first heard the name Nate Paul?
Not with precision. The first,
Ballpark.
Probably 2019, and I heard that name come up in the weekly updates from David Maxwell and Mark Penley.
Were those at the meetings of all the deputy chiefs?
At times, and there were also private meetings at a regularly scheduled time with Mr. Mateer and myself and that particular deputy.
And what was the context of hearing that name? What was going on?
I was aware that at first,
Objection. I'm sorry, Your Honor, to interrupt. This is based on hearsay. Objection, hearsay.
Not offering it for the truth of the...
Sustained.
Missy, when you heard the name Nate Paul, what was it in context to?
Your
What
Honor,
was it
just-
related to?
Can I finish, please? It's the same question, hearsay. Objection.
I'm not offering it for the truth of the matter asserted. I'm trying to show the context in which she's known that name.
It's not an exception to the hearsay rule, Your Honor. It's hearsay.
Sustained. Sustained.
When you heard the name of Nate Paul, did you do anything? Were you involved at all?
no, I was just listening
Okay.
to the updates.
At some point, did you become aware of a contract?
Objection, Your Honor. Hearsay.
I'll
You
reword
just
it.
said she wasn't involved and
I'll
she
reword
heard
it.
about it. So everything she knows about it, somebody told her.
I'll reword it. At some point, did you become aware of a contract that had been set aside for Brandon Kamek?
Yes.
When did you learn about that?
I recall being told,
Objection. I'm sorry, Miss. Your Honor, she's just telling us right now that everything she knows is hearsay.
I'll reword it.
Sustained.
Without telling us what somebody said, tell us first of all the time frame of when you became aware of it.
I'm just not sure I can tell you the exact time frame.
Okay, a ballpark's fine.
No, it's not, Your Honor. That's pure speculation. Ballpark is not good enough under oath in court.
Sustained.
Did you get a phone call from General Paxton about a contract for Brandon Kamek?
I did.
When did that happen?
September 28th of 2020.
All right. Where were you?
I was at my ranch in Mason, Texas. I got a call on my cell phone.
Okay. Was this COVID? Were you at home
I was.
working from home?
It was.
All right. The first contact you had, what was it from the general?
The Attorney General called and asked me for some advice, given my experience in the outside counsel world, about an outside counsel contract he was interested in entering into with Brandon Kamek. And so he called and asked me how the process worked.
And what did you tell him?
I told him how the process worked. We talked about the statute. We talked about the rules. We talked about the internal procedure of how it worked. He was interested in pursuing an outside counsel contract with him.
On September 28, did he make you aware that there had been a problem with the contract that was going through the office for signature for approval?
He did.
Did he tell you who was holding it up?
He did.
Who did he tell you?
Mark Penley.
And did he ask you how to get that contract in effect without that signature from Mark Penley?
He did.
What did you tell him?
I told General Paxton that I believed, given my experience, that he, as the Attorney General, could sign an outside counsel contract with Mr. Kamek if he followed certain procedures that weren't able to be waived,
Okay.
which is the best interest standard in order to pay him. Then I also told him he could waive in writing based on 1 Texas Administrative Code, Section 52.7C, that if the Attorney General or the First Assistant waives the internal procedures in writing, then they can all be waived, the ones that aren't statutory or required by the Appropriations Act.
So the waiver can happen by the Attorney General or First Assistant, but it has to be in writing. Is that correct?
That's what the administrative rule says.
All right. You also mentioned that despite that, the standards of whether or not that contract is in the best interest of the state still applied. Is that correct?
Standard of whether the contract met the best interest of the state in order to be funded still applied, yes.
All right. So he can sign a contract on his own as long as he provides a written waiver. How about funding?
So at the Office of the Attorney General, there isn't an account set aside for outside counsel contracts. The money has to be moved from what is called the First Assistant's Reserve, which is some funding that's at the First Assistant's discretion. That money can be moved by in writing to the budget people and set aside the money. Then the money is coded and applied to the outside counsel contract.
So can be done, but should be done. Are those two different questions?
They are.
Did you talk with him about whether or not it should be done?
I did.
What did you tell him?
Since he had already told me that Mark Penley was refusing to sign, we talked about why that could be, that Mark Penley didn't want to sign, and why Jeff also did not want to sign, and that it was going to be really hard to get over the best interest standard until we resolve that, which is the funding part, not whether or not it was legal for the Attorney General to sign his own outside counsel contract.
Okay. How did he respond when you told him that?
He was very appreciative of the advice. He asked me if I could text him the statutes and the rules and the procedure so he could see what we were talking about, and I did that.
Before you hung up with him, did you tell him this was ill-advised?
I did.
Objection. Leading.
Sustained.
What did you mean by ill-advised? In your opinion, what does that mean?
Your Honor, if I could, I mean, obviously you sustained the objection, and now she's going right back at it and now testifying herself.
Would you sustain, or would you
I'll reword it.
reword it?
When you advise someone that a contract shouldn't be done, can be done, but shouldn't be done, how did you tell him?
I would have used the word ill-advised. That's just kind of a word I use.
And did you tell him why it was ill-advised?
I did.
What did you tell him?
I told him that his senior staff felt like that this contract was a problem and they didn't want him to do it, and that we needed to resolve that and be on the same page.
Okay. Was there continued contact from Ken Paxton concerning this contract?
He emailed me back the next morning after I sent him the stuff in writing and said he appreciated it. He did call me back again the next day, a couple hours later, and we had the conversation again. We talked about all these same things again. Then I think he might have reached out to me on October the 1st, but I did not return that call.
Okay. That last phone call you had with him, what was the content of it?
It was very similar to the content of the first conversation.
So he wanted to know how he could do it?
Follow-up questions about, now, didn't you say that I could do it this way or that way? And we went through that again, and how the funding worked again, and how to make it happen.
That last phone call that you had with him about how to make it happen, did you talk with him again about why he shouldn't make it happen?
My recollection is I was much firmer on how strongly the executive team felt that it was ill-advised.
Okay. I wanted to talk about his demeanor on the telephone during that particular phone call. Would you describe it?
The second phone call?
Yes.
His demeanor, it was like I was on speakerphone and somebody else was listening, which concerned me.
Why did you think that?
Your Honor, I'm sorry. I'm going to have to object. This is rank speculation, and I object under 602.
Overruled.
You've known him for how many years?
Since 2015.
You've known him through good times and bad times?
I have.
Tell us, based on your knowledge of him, what your impressions were of that phone call, of his demeanor.
It was unusual. It was like I was speaking to somebody besides him, because he's very bright and he knew exactly what we had talked about the day before, and it was a repeat of the same thing, like I was playing to an audience.
Did you think that it was a phone call where it was a private phone call, like telephone to ear?
Objection again, Your Honor. This is speculation. She doesn't know if anybody was there with him, and she's just speculating.
I'll ask it a little differently.
Yes.
Did you have an impression that you were not on a direct private telephone line with Ken Paxton at that time?
I was concerned about that, yes.
What did you think?
Again, Your Honor, what she thought is irrelevant, and it's also speculation.
Sustained.
That phone call obviously made you very uncomfortable. You've said that. What about it made you uncomfortable?
General Paxton's persistence to do this, knowing his senior staff objected, which was very unusual. And it was also unusual to me that he chose to call me and talk to me about it, since we were not on the best of terms.
Let's talk a little bit about these types of contracts. To create a contract and assign responsibility to an outside attorney, are there certain parameters and limitations?
So the outside counsel process was designed in order to protect and preserve the Attorney General's office's constitutional and statutory duties to represent the state. So necessarily, a grant of an outside counsel approval is a granting that in the first instance, those activities would have been within the course and scope of something the Attorney General's office could do, if that makes sense.
And are the scope of duties of the Attorney General's office lined up with civil law? In other words, are they civil properties?
I mean, it's civil. There's civil parts of it. There's also the ability of the Attorney General's office to assist prosecutors on request.
Okay.
If that's what you're asking.
That's what I'm asking.
Okay.
So talk with me for just a minute about how we get to prosecution. What has to happen? What has to happen for the Attorney General's office to be able to prosecute legally?
Well, if the Attorney General's office wasn't provided statutory authority by the legislature to have sole prosecutorial authority in the area, those sorts of questions are ones that come from a request by a constitutional district attorney or county attorney for assistance as a general rule.
Okay. So can the district attorney limit the scope of the ability of the office to do that kind of work?
I'm sure they can. They pick and choose what they decide to send over and what they ask for.
During all the years you were at the AG's office, have you ever seen the Office of Attorney General hire outside counsel to handle a criminal item?
I don't recall hiring outside counsel to handle a criminal item.
Are those large divisions within the office?
Some of them are larger than others, but we have prosecutors on staff, we have peace officers on staff.
So they're qualified people within the Attorney General's office to handle those types of things?
Yes.
Okay. I want to talk about the contract, in particular, the CAMIC contract. Have you seen it? Have you been able to look at it?
I have seen it.
All right. I want to talk about the contents of that. The limitations were provided on that contract, were they not? Was there an
Yes.
addendum A that?
Addendum A is generally the scope of work that the outside counsel is being requested. That's how it's set up in the form.
Okay. And based on your research, what did that addendum A track? What language was that?
Can you show it to me, please, ma'am?
See, 227, please. It's in evidence.
If I could see addendum A, please, ma'am.
We need addendum A, please.
I have it.
Whoops.
Thank you.
Yeah. Do you recall looking at that language?
I have read this language before, yes, ma'am.
And was that language tracked from the Travis County District Attorney's Office referral letter? Did you take a look at that?
It appears to be very similar.
Okay. And is it a limiting type of language?
I mean, I think by its nature, all scope of services are limiting in their language.
This particular contract, though, does it give?
Your Honor, I like to object. Can we get some foundation here? She was not involved in this other than the phone call she just talked about. And we heard Ryan Vassar, who drafted this. So this is all something she learned later, and she shouldn't be up there testifying about it.
Missy, do you have a lot of experience in these contracts?
I'm talking about this particular contract, Your Honor. She just asked it again. This witness was not involved in the drafting of this contract.
This witness does not have to be involved in the drafting of the contract to give an opinion concerning it or to talk about it. That's not required under the law.
Moreover, and thank you for that. Moreover, Your Honor, now she's asking her to give some sort of legal opinion, which certainly she's not been proffered as an expert. They don't have any experts in this case.
She's a person who teaches. This is an area of her expertise. She's talked about the thousands of contracts that she's looked at and approved.
Just settle this. I'm going to overrule. Continue.
Thank you, Mr. President.
Can you repeat the
Take a
question?
look at addendum A, and there's a limitation in there concerning the ability to do what? What is it authorizing Brandon Kamick to do?
Let me take a second to reread it, please.
Certainly.
The contract provides that pursuant to a request basically from the Travis County District Attorney's Office, that the outside counsel will conduct an investigation under the authority of the Attorney General's Office of the criminal allegations contained in the complaint.
It says to conduct a review, does it not, in the very
does.
first paragraph?
It does, a review and
Of the allegations.
a review of the allegations, and then the third paragraph, conduct an investigation.
Okay. Does that particular contract authorize prosecution of a case?
The last sentence in the contract excludes legal services relating to post-investigation activities, including but not limited to indictment and prosecution.
So it excludes that.
Correct.
All right. I want to talk about this contract that you were consulted about by Ken Paxton himself. Is there a problem with Ken Paxton signing a contract like this to provide services when he's authorized him at least 2 weeks ahead of time to start providing those services?
I have never been made personally aware of when Ken Paxton signed this contract, so I don't think I can answer your question.
So what I'm asking you is, if he had authorized Brandon Kamek 2
Your Honor,
weeks earlier,
I'm
let
sorry.
me finish my question, please.
There's no reason to yell. Your Honor, I'm sorry, I have to object that counsel is putting facts that are not in evidence. The witness has already told us she has no personal knowledge. This is completely improper, and I object.
She is an employee who's familiar with the procedures and whether or not things are proper or not. In fact, she's being consulted about it, so I think I'm entitled to ask her.
Overruled.
Thank you.
Can you repeat the question, please?
Is there a problem if the contract was signed by Ken Paxton and he had authorized the services to be performed weeks ahead of time, before that date of signature?
The contract should have, in the first pages, an effective date of the contract. And I don't have in front of me what those effective dates were, but the effective dates need to line up. It's not the time of signature, it's the effective date of the contract. But there's still the problem of the funding. It's unresolved.
What if there's no date at all because it's not been put on there?
Then I would be speculating as to whether or not the contract was signed before the date of the effective date of the work.
Okay. Assuming that your advice to General Paxton about his ability to sign it under that little provision, would it be properly done if he did not provide a written waiver?
If he did not provide the written waiver required by the rules, then the procedure should have been followed.
Okay, so you either follow the procedures or you have to sign it and give a written waiver as the Attorney General. Is that correct?
That's the process.
All right, so without that written waiver, where are we?
It's merely a violation of the process. It doesn't make it illegal, it just makes it a violation of the process.
How about funding it? What does it do to that?
Without the proper written indicators to the controller, they're not going to pay the invoices, even if the money's there.
The Addendum A talks about a referral from the Travis County District Attorney's Office. If General Paxton had added a second referral and told Brandon Kamek just do the whole job, is there a problem with that, with a contract that's not authorizing the work to be done?
I don't know that I'm comfortable speculating to that.
Then I object, Your Honor. The witness has admitted, thank you, that this would be all speculation.
Sustained.
What are your thoughts on that?
Your Honor.
I'd like to let her finish the thought, as far as she's not rendering an opinion, but I'd like her thoughts on it.
Again, Your Honor, she just said this would be mere speculation, so this is improper.
Sustained. Sustained.
Are you familiar with the attorney applicants who applied for this particular contract?
I'm familiar with their names.
Okay.
I do not know them.
Was Brandon Kamek the qualified candidate?
I don't think I was ever asked to weigh into that question.
Not asking you that. Having looked at all these contracts and you've said you have to have a qualified candidate for the job, looking at those two, was Brandon Kamek the qualified applicant for it? Was he the best choice?
It was not my decision to make who the best choice was.
Not asking that, I'm asking your opinion as you sit here today.
Ask and answered, I think.
Would it ever be in the best interest of the state to pay for a free investigation to a private citizen when there's no state interest involved?
So you're hypothetically asking me if it's proper to execute an outside counsel at $0 for an investigation where there's no state interest involved at all?
Correct.
I'm not sure it's possible to execute an outside counsel contract where there's no state interest involved, because ability to contract with an outside counsel derives from the ability of the Attorney General's office to represent a particular client in a particular matter.
We're talking about a cost, right? We're paying somebody other than an in-house attorney from the OAG to do the work requested, correct?
Statute, the government code in 402-0212 that describes outside counsel talks about the full-time employees of an agency don't count against as being outside counsel.
Right.
It's when you hire a counsel that's not employed by the state.
So my question is, when you're paying someone like Brandon Kamek outside of the state to provide services that benefit only one individual for a job that is not in the best interest of the state, do we have a good contract?
I'm sorry, Your Honor, objection vague. Question's completely vague.
Sustained.
You said that in order for a contract to be approved and signed from the Office of Attorney General for an outside counsel, the whole contract has to be in the best interest of the state, right?
Yes, I mean, that would be ideal. It's not because that comes from the Appropriations Act, but the state should not perform acts with taxpayer dollars that are not in the best interest of the state, in my opinion.
Right. And so if it's a job that's only going to benefit a citizen and has nothing grounded within a state interest, that's not a contract that should be approved, is it?
Objection leading.
Sustained.
Is that the type of contract that we want? That we should be approving?
I'm sorry, I don't know who "we" is, but objection vague.
Sustained.
Let's talk about September 28th. That afternoon, after you spoke with Ken Paxton about this contract, did your phone start blowing up?
I talked to General Paxton, I believe those phone calls were in the evening on the 28th, not in the morning.
And who were you getting the phone calls from?
So when General Paxton called me, because he hadn't looped me into his world in a while, I did call Jeff Mateer before I called him back, and Jeff relayed, said...
Objection, hearsay.
Sustained.
Later on that evening, who did you speak with?
Mr. Mateer.
Did you speak with anyone else other than him?
After I spoke to General Paxton, I don't believe so. It was late.
Okay. Following day, did you receive some phone calls from other people within the office?
I did.
Who did you hear from?
I think there was sort of all involved deputies call with a number of the deputies that's been previously reported on that I was on the telephone for.
Okay. And how long were you on the phone? What
Hours.
kind of time frame? All right. How many of you were on that call?
I mean, I would say 6 to 8 of us at various times, sometimes up to 10, and people were in and out of the call.
What was going on?
There had been some subpoenas issued by Mr. Kamek that some of the staff had known about and reported, and the deputies were getting together with Mr. Mateer to discuss those facts and the circumstances around what was happening at the time with him.
Was Nate Paul at the center of that conversation?
Objection, hearsay.
Topic. I'm not asking her to repeat what was said.
Overruled.
Was Nate Paul the topic?
Yes.
Did you learn about several things that had been going on in the office?
Yes.
Any idea why you were not aware of those things before that date?
I believe that due to COVID and everyone being home and not on the same floor working together and people coming in and out on different days of the office in the middle of the pandemic, we were not all together at that time as a team in the same place at the same time. And so there wasn't complete awareness like there usually would have been of what each deputy was working on with relation to Mr. Paul and General Paxton.
So as a result of that long phone call with the group, did you come to learn, I'm not asking you to repeat, but did you come to learn about those things that had been happening within the office?
I did.
And what was the connecting theme of those things?
Mr. Paul.
All right. As a person who's spent so many years worrying about ethics and how things should be managed within a government office, what were your thoughts about what was going on?
I was surprised at the level of involvement from the Attorney General with one particular person that reached across so many levels of the executive staff, all related to one person.
In the course of your career, have you ever experienced something like that before?
Not related to a particular person as opposed to a particular topic.
Okay. Tell us what your concern was ethically with what had happened.
I learned that the contract was executed, even though the conversations I was having with General Paxton, he never told me that the contract was already executed. We were approaching the conversations as if it was not a fait accompli and had not been done. So I was very surprised by that. And I was surprised by how many different things related back to a use of resources by the agency for one person.
So, what's the big deal with that? Who cares?
Objection, Your Honor. I mean, I
What's
don't know
the
what
deal?
that is. That's not a question. It's not a proper question. I object to it.
Sustained.
What's the problem with all of those resources going to one person?
Besides it being unusual, it was unusual, and there was a lot of speculation about the underlying reasons during that phone call.
Okay. Was there any resolution with that phone call? Was there a decision to do something?
On the 29th,
Yes.
there was not.
How about the 30th, the next day?
There was.
And what did you decide to do? What did the group decide to do?
The group felt like, some of the group felt like they had an obligation to report to law enforcement.
Why would they do that? What was the problem
Objection,
with...
speculation. She's asking about people we've already heard from. Tell us what they were thinking. We've heard from them.
I'll reword it.
Sustained.
I'll reword it. At this point in time, what was the problem with what had been going on? What was the concern in your mind?
A concern in my mind was the immense amount of effort that was being put to the problems of one particular individual when so many of the executive staff disagreed with that. And I'm a consensus builder, and there was not consensus on how to move forward on these things.
Was it the degree of that?
Objection,
amount?
leading.
Sustained.
When you looked at all of the events that you learned about, and you looked at the people that had been involved with it, did you, in your mind, figure out how much of the office had actually been dedicated to doing work for Nate Paul's benefit?
I did.
What kind of number did you come up with? How did you describe it?
I think at the time I mentally came up, it was more than 50% of the deputies' time of our entire executive staff.
You ever seen anything like that in your career?
I had not.
All for the benefit of who?
I don't know that I can answer who it was for the benefit of. What I can answer is the commonality
Objection.
and the thread.
Sorry, ma'am. The witness just told us she can't answer the question. Next question.
And what was
Sustained.
the commonality of it that you were about to talk about?
Nate Paul was the commonality.
All right. And the other commonality would be who directed it, and who is that?
Attorney General Paxton.
When the Attorney General's office does something that totally violates its long-time policy, for example, something like open records and not disclosing information for pending law enforcement, honoring the law enforcement exception, and not releasing documents that have to do with ongoing criminal investigations, what's the effect? What kind of things happen to the office and to the public?
Your Honor, that is a completely improper question. This person is not even involved in public information at the office. Moreover, the question is 3 or 4 different questions.
Sustained.
It's improper.
Do you have experience in open records?
I do. I was the public information coordinator for the Office of the Attorney General. I was the division chief of the division, and at the time that you're asking about, I was the supervisor of the public information officer for the Office of the Attorney General who had briefed that particular ruling to the Open Records Division.
So when you violate the policy, the long-standing policy to protect that type of information, what does it do?
Your Honor, that assumes, she just said she approved this, and now the lawyer is saying that she violated some policy. That's improper.
That's incorrect. I've not said anything
Overruled.
like that. What's the long-term effect? What happens? What's the concern?
When the Open Records Division changes long-standing precedent in their rulings, it can create confusion, and it is a proactive statement of precedent on other rulings in that area.
And when it's broken, what does that mean? That precedent's gone.
All the governmental agencies have to adapt to that new precedent across the board with every request that's similar.
Did you go with the others to the FBI?
I did not.
Why not?
I had retired, and so I did not. I was invited to the meeting, and I was 3 hours away, and the meeting, I was told that unless you came in person, don't come.
Did you have an occasion later on to go talk with the FBI about your observations?
I was subpoenaed by the grand jury to talk about my observations in 2021.
Okay. And did you do that?
I did.
Did you
I
cooperate?
complied with the lawful subpoena.
And your name is not on the whistleblower letter, is that correct?
I am not a whistleblower
Why is that? Why did you not sign the letter?
because when the time all this was happening, I had already submitted my notice to retire, and my retirement was imminent. So, for lack of a better word, I was a quitter. I had quit.
Pass the witness.
Mr. Busby, your witness.
Yes, Your Honor, thank you. Hello, ma'am.
Mr. Busby?
You look like you're a little nervous.
I'm not nervous.
Feeling good?
I don't think anybody particularly wants to be here, Mr. Busby.
Let me ask you something. You said you appeared in front of the grand jury,
I was subpoenaed to appear at the grand jury.
and that was in 2021,
Yes, sir.
and it's 2023 now,
Yes, sir.
and that you told them everything you told us here?
I answered their
I
question.
object. If she's appeared before a grand jury, she cannot talk with us about what she testified to.
You can tell me that if that's the case.
Sustained.
So suffice it to say, your story hasn't changed since 2021, right?
Can you explain to me what story I'm talking about?
I'm wondering why the so-called whistleblowers who reported this to the Travis County DA's office and to the FBI and maybe others, and you who spoke to apparently the FBI or the grand jury at some point, why nothing's happened, even though every single thing that we've heard in this impeachment has already been fully vetted. Can you tell me, has there been an indictment of our Attorney General?
So your question is,
Has there been an indictment of our Attorney General?
not that I'm aware of.
Okay. You think that Laura Olson drives a red car? Is that what you told us?
I did not say that. I said the person at the Galaxy Cafe that I saw drove a red car. I've never said it was Laura Olson for sure.
Why are you even telling us about somebody that drives a red car at the Galaxy Cafe when Laura Olson never owned a red car?
That assumes facts that are not in evidence.
Sustained.
Do you know whether Laura Olson has ever owned a red car?
I do not.
Do you know what kind of car Laura Olson would have been driving back in that time frame?
I do not.
Okay, so you just got up here in front of all these people watching at home, our distinguished jury, and was telling us about some unknown person driving a red car at Galaxy Cafe, and you don't even know who that was, do you?
That would be correct. That's what
Why
I
the
said.
devil are we even hearing about the Galaxy Cafe? You didn't know who that person was.
I never said that I did.
How long did you work with these people over here to prepare yourself for your testimony?
I didn't work with them. I was asked to go in front of the House managers and interviewed, as well as talk to you and your staff.
Are you sure there was some sort of Attorney General's conference in San Antonio in that time frame?
The best of my recollection.
There wasn't. I guess I'm trying to figure out, well, how good is your memory?
Is that a question?
Yeah. Not very good, is it?
No, sir, it's not.
That's what I thought. Ken Paxton was your boss before you retired, right?
Yes, sir.
You told us about all this teaching you've done in CLEs, continuing legal educations, right?
Yes, sir.
You've taught students, you've taught other lawyers, right?
Yes, sir.
And you sat up here and you were trying to explain to us contracts and how the process works, right?
Yes, sir.
And your boss called you because he wanted to legally do the right thing, and you provided him advice, didn't you?
Objection calls for speculation on the part of this witness.
Sustained.
He wanted to know how to properly sign an outside counsel contract, didn't he?
Objection calls for speculation.
It's exactly what he told her.
Objection.
Overruled.
He wanted line and verse. What do you call you, Missy? Is that what he called you?
Yes, sir.
Missy, look, I'm having a disagreement with this Penley fella. He's refusing to do his job. He's insubordinate. I need to know, under the statutes, if I have the authority, the legal authority, to sign a contract. And you gave him advice, didn't you?
Yes, sir.
And you said, Ken, you do. Isn't that right?
Correct.
Why are we here? The guy did everything he was supposed to. He had some insubordinate people in his outfit.
I object.
So
Counsel's testifying, not asking questions.
That is a question. I'm not finished.
Sustained.
You knew that Penley refused to follow the procedure and sign off on the contract, right? You knew Penley said, I ain't going to sign it, right?
I knew Penley said he did not want to sign it. Correct.
The only person in the office who has authority to sign the contract himself, unless designated, is Ken Paxton. Isn't that right?
That is correct.
Let's make sure we're all clear on that. This bureaucratic process that this person signs and this person signs and this person signs, all of their power and authority to sign a contract comes from the elected Attorney General, Ken Paxton. Isn't that true?
Subject to the Appropriations Act, the statutes, and the rules that we adopted. Correct.
Right.
Yes, sir.
So, we saw Mr. Penley's notes. If he said in his notes, Missy told Ken he had the authority to sign the
That
contract.
violates the rule. Sorry.
You can
that
keep objecting.
violates
This
the
is a
rule.
document that's in evidence, Your Honor. We all looked at it.
Overruled.
When we looked at Mr. Penley's notes,
I
it-
object.
you can object again, but it's in the evidence, Your Honor. You saw it. We all saw it.
I object to him testifying about a document that this witness has not established that she's ever even seen. That's improper.
That's not right, Your Honor. When I asked her if Penley's notes are correct, that is, Missy told Ken he
I'm
had
asking for a
the
ruling,
authority
Judge.
to sign a contract. That's an incredibly appropriate question.
Sustained.
Now, you did tell Penley that you had told Ken he had the authority, right?
I told everyone on the phone call, then Penley was one of the members of the phone call, correct?
Let's make sure we all get that right. And your job at that point in time when you told Mr. Paxton that was?
His chief of staff.
The chief of staff of the Attorney General's office of the state of Texas advised her boss, the Attorney General, that it was okay to sign an outside counsel contract, correct?
I told General Paxton that it was legal for him to sign the outside counsel contract, correct?
And then later, when everybody was scrambling around, you told his entire executive staff that you had told him that, right?
I was completely honest with him, yes, sir.
And they still went to the FBI, didn't they?
They, in fact, went to the FBI.
That's right. Are you somebody that goes to church?
I'm not sure that's an appropriate question, is it? My personal beliefs?
Well, it is when you're telling us about the ethical, legal, and moral implications of an affair. Remember telling us all that? Remember saying that? Maybe, I think you said political, ethical, legal implications of an affair. Remember saying that?
I remember giving the Attorney General my thoughts on those topics.
Okay, so I'm gonna get your thoughts on the topic. You ever met somebody that's perfect?
Never, sir.
Okay, was there only one person that was perfect?
In my belief system, there's only one entity that's perfect.
All have sinned and fallen short of the grace of God, right?
I would agree with that, sir.
Yeah. Sometimes people make stupid mistakes, correct?
Yes, sir.
Sometimes, I mean, imagine if we impeached everybody here in Austin that had had an affair. We'd be impeaching for the next 100 years, wouldn't we?
I don't think I should answer that question in this chamber, particularly. I've been around a long time, Mr. Busby. I'm not going to go there with you.
I'm quite sure you've seen a lot, have you not?
Indeed.
Yeah, just because somebody has an affair doesn't mean that they're a, quote, criminal, does it?
I would not associate that directly.
Yeah. I mean, that would be incredibly hypocritical, would it not? If somebody said, this guy is a criminal because he had a marital indiscretion. That would be really hypocritical, would it not?
I would not say that.
Yeah. You would never say something like that, would you?
I would not.
You even sent in those, when you were texting back and forth with Ken Paxton, your boss, you sent him the legal authority that gives him the authority to sign contracts, right?
Correct.
Okay. And you also referred him to the Attorney General's website, didn't you?
With the procedure, yes, sir.
Yeah. So you not only told him over the phone, but you also sent him the exact statute and the website, the AG's website, right?
I did.
Okay. Did you ever figure out how the grand jury subpoenas were actually obtained by Mr. Kamek?
I did not.
Okay. You know, of course, he didn't have to appear in front of any grand jury, right?
If you tell me that, then, I'll take your word for it. I didn't dive into that. Again, I had told General Paxton that the contract was legal to sign,
Okay.
but couldn't be funded. He had a funding issue.
Well, okay, we'll talk about the funding issue. The funding issue is something of course, Kamek didn't get any money.
I do not know that.
Okay.
Are you telling me Kamek didn't get any money?
Young man did a lot of work, didn't get paid.
I object to defense counsel testifying.
I'm asking if you knew
I
that.
object.
Sustained.
Did you know that he never got paid?
I did not know that until you just told me.
Okay. Let me ask you, would it be an appropriate process for the Attorney General, before you even try to go through the executive approval memorandum process, that's a bureaucratic process, is it not?
Correct.
Okay. It's a bunch of procedural rules that have no force in law, right?
It's a documentation that is not the legal document.
Right. Oh, gotcha, you didn't follow the procedure in the office. The AG can decide what the procedure in the office is, can he not?
He could waive the procedure in writing, yes, sir.
He can waive it in verbal. He can do what he wants as long as he believes he's serving the people of Texas. Isn't that right?
Well, he agreed to the rules that said it would be in writing.
And he can change the rules.
If he goes through the Texas Administrative Code process in this instance, he could change the rules, yes.
Let me just ask this, though, so we're all clear. Can the AG of our state send an email to the controller? Is there a controller in the office? Somebody in charge of the money?
There's a controller in the office, and then there's a Texas controller.
Yeah, I'm talking about the internal one. Who was the internal controller in the AG's office?
Michelle Price.
Can the AG send an email to the controller within the office and say, set aside $50K or $25K for a contract I'm going to sign?
He can.
Okay. Is that something that he has the authority to do?
Yes.
Okay. Does anybody else have that authority?
The Appropriations Act in Article 9, Section 16 says the communication needs to go to the controller. So that communication would need to be forwarded to the controller to prove that the Attorney General felt it was in the best interest of the state.
The Attorney General. No one else.
The Appropriations Act uses the words Attorney General, and as you correctly stated, those kind of things he can delegate, but if he didn't delegate, it says Attorney General. Yes, sir.
If he did not delegate, it would be illegal. True?
I don't understand the question.
Let's say that one day Mr. Penley decides that he wants to set aside $50K to sign an outside counsel contract. That would be illegal, wouldn't it?
I don't think it would be illegal. I don't think anyone would do it for him. The controller would be following the procedures.
You think so?
I do.
Okay.
I have
Let's
faith
look
in the
at
staff.
let's look at an evidence we've already seen. Exhibit 361. Can we put it on the screen for the witness? Eric, can you help me out here, Eric? Everybody likes Eric, Your Honor.
And Stacy.
And Stacy. And Stacy. If you don't mind, Eric, go to page 4 of AG Exhibit 361. Do you see that there in front of you? Jeff Mateer is authorizing $50,000 to be set aside for a guy named Johnny Sutton. Do you see that?
I do see this.
Did you know that was going on?
No, sir.
Did they tell you they were doing that?
No, sir.
Do you think that the first assistant has the authority to hire outside counsel with an email?
I do.
You do. But Ken Paxton doesn't?
I believe that Ken Paxton could have sent a very similar email if he did about the funding, and he would have achieved the same result. If he did, you may show me that documentation if you like. I'm not aware of it.
I thought we had this real strict bureaucratic procedure to hire outside counsel. Remember you telling us about all that?
We do.
Okay.
And in that procedure, the first assistant has been delegated that authority.
No. Ken Paxton did not delegate any authority to hire Johnny Sutton. No, you know that's true.
I object. That's a misstatement of what she said.
Do you know whether Ken Paxton...
Object.
I'm going to rephrase the question.
Sustain, rephrase.
Do you know whether Ken Paxton, the boss, authorized Jeff Mateer, the subordinate, to set aside $50,000 for Johnny Sutton?
I have no personal knowledge of Johnny Sutton.
Okay. Pass witness.
Redirect?
No, sir.
Are both sides can excuse the witness?
You are finished
Yes.
with this witness.
Yes.
You may step down, thank you. Yes. You are excused.
Thank you, sir.
She asked, is she subject to recall? Subject to recall?
No, Your Honor. I think we're done with this one. Nice to meet you.
Thank you. Who's your next witness?
Your Honor, the House calls Greg Cox.
Bailiff will bring in Greg Cox.
And Mr. President, if I may, in an attempt to hopefully expedite the process. I have one piece of evidence that I intend to show while Mr. Cox is on the stand. It is exhibit number 249, whose affidavit attached is number 640. It's a video before the Senate Finance Committee from February 10th, 2021. It is a government record, and it is authenticated by the proper affidavit associated with it. We'd offer the same in evidence.
You're going to submit that, right?
I'm offering it as evidence, Your Honor, because I intend to play it with the witness.
Do you have
To
any
expedite, I
objections?
was hoping to get any objections taken care of beforehand.
Do you have any objections?
No, Your Honor.
Mr. Cox, raise your right hand. I do solemnly swear or affirm that the evidence I give upon this hearing by the Senate of Texas impeachment charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, and nothing but the truth, so help me God. Please take your seat. Court will admit into evidence Exhibit 249 and Exhibit 640.
Thank you, Mr. President. May I proceed? Good afternoon, sir.
Good afternoon.
I'm going to need you to speak a little bit closer to the mic. I'm never really told that nobody can hear me, but I know that acoustics are not great, so please step forward or slide forward to make sure we can hear you.
Very good.
Would you please introduce yourself to the honorable senators?
My name is Greg Cox.
And tell us, sir, how you're currently employed.
I am currently the first assistant with the Hays County District Attorney's Office in San Marcos.
Could you give us, please, a quick briefing of your history, professional and perhaps even law school, that led you up to this point?
Yes, I attended law school at the University of Texas, and actually during my first year of law school, I worked here at the Texas Senate. Took a year off from law school, worked for an accounting firm, and then when I went back during my second year, I got a job as a law clerk at the Travis County District Attorney's Office in the Public Integrity Unit. Upon graduation and passing the bar, I was offered a position as an assistant district attorney, and I ended up staying with the Travis County District Attorney's Office for 30 full years.
After leaving the district attorney's office in those 30 years of service, did you go to another government or quasi-government job?
I did. I initially went and was general counsel in 2021 at the Texas Civil Commitment Office, a small state agency that oversees people that have been civilly committed as sexually violent predators. I left there and went to the Texas District and County Attorneys Association, where I was assistant director of training. And then in January of this year, I became first assistant in the Hays County office.
I appreciate that, sir. Thank you. During your time at the Travis County District Attorney's Office, you indicated you were Director of Special Prosecutions Division. Did that include investigations into public corruption?
Yes, it did. I served as Director of Special Prosecutions, which included the state-funded Public Integrity Unit while it existed for 15 years, the end of 2021 to the end of 2016.
I figure you might get some questions about that, but I'll let my colleagues take care of that. Let's move on then to your time at the District Attorney's Office towards the end. Who was the District Attorney, not the last elected District Attorney that you served under, but second to last, if I'm asking that right?
So,
let me ask it a better way. Do you know Margaret Moore?
yes.
Okay.
So 2017 through 2020, Margaret Moore was district attorney. During her administration, I was serving as Director of Operations.
Very good. Did she ask you at some point to speak with her, or let me ask you this, did you flag a concern for her related to a possible open records request?
In October of 2020, one of my responsibilities was overseeing public information. I became aware of an open records request that the office had received related to Ken Paxton and Nate Paul. I didn't know what was going on. I asked a question about that. She briefed me on some things that had been going on that I had been unaware of, and then asked me to start joining into some meetings with some individuals related to that.
Is it fair to say that up until that point, you had not heard the name Nate Paul in relation to the Travis County District Attorney's Office?
That's correct.
Very good. Then who did you speak with at Ms. Moore's request?
Initially, I spoke with a couple of lawyers that represented the Mitty Foundation.
And let me back up. I poorly phrased that question, as I often do. Back that up to say, Ms. Moore, you indicated wanted to speak with you.
Yes.
About this request. Did you speak with Ms. Moore, and was there anybody else present?
I spoke with Ms. Moore and Don Clemmer. I may have spoken with Mindy Montford, although I can't recall that for certain.
And based on what you learned during that conversation, was there a next step that you took?
I drafted up a real brief overview of potential criminal offenses that could be relevant to the situation that they briefed me on. And then we set up a series of meetings to gather more information.
Do you recall approximately when it was that you drafted this initial, well, I'm going to call it a skeleton outline?
If I am recalling the dates correctly, the initial conversation was on October 21st of 2020. I drafted the first memo on October 23rd, which was Friday of that week. And then Monday, Tuesday, and Wednesday of the following week, we had a series of meetings. And then I believe it was on October 28th that I drafted a more thorough memo about the situation.
Your Honor, if I may approach the witness after I ask the following question, I'm going to show you what I don't intend to introduce into evidence, but would ask if you would rely on your memo to refresh your memory.
Sure.
Objection, Your Honor. He hasn't said that he doesn't remember anything yet.
Fair enough,
He can't sit up there and testify from a document that's clearly hearsay.
Your Honor, I'll rephrase. I apologize. Thank you. And Mr. President, I keep saying Your Honor, force of habit.
Whatever's comfortable for you.
Thank you, sir. Do you have a full recollection of each and every item that you outlined in your October 28, 2020 memo?
I have a reasonably good recollection of it.
Do you feel that looking at that would assist and aid you in your testimony in order to provide comment to the ladies and gentlemen of the jury and not waste a lot of time?
I do.
May I approach the witness, Your Honor?
Your Honor, may I again, and again, I'm all about saving some time, but this is not proper to give him a document that he hasn't said, he didn't ask a specific question about, do you remember this, remember that? You don't just refresh your recollection with an entire document. It's not how it works.
Your Honor, respectfully, I've yet to hear a single objection on this issue from Mr. Busby other than his complaints about it. I will proffer to the court, if I may, sir.
It's hearsay. You're not allowed.
If I may, sir, I thank you. I've allowed you to continue your objections, and I ask you to give me the same decency. Your Honor, this witness is testifying that he created a report. He has testified here today that he doesn't have full memory of everything contained in that report. And Mr. President, he has said that it would assist him in providing testimony to the jury.
Overrule the objection.
Thank you. May I approach Mr. President?
Yes, you may.
I hope I'm not the only one that's ever happened to, because my wife will take care of me later on. Sir, tell me, after your initial meeting with Margaret Moore and Mr. Clemmer, what steps did you take, if any?
So the initial conversation, I was provided a briefing of some facts that they knew at that point. I then went and looked at some basic open source information to gather some additional facts, and I drafted an earlier version of this memo that did not include any fact summary. It only included an outline of potential criminal offenses that might be avenues of investigation. I provided that to Ms. Moore on Friday the 23rd, and then we had the series of meetings that I referenced a moment ago, and I drafted this memo after that series of meetings.
Do you recall the individuals who you spoke with? And I'm not asking you what they said, just the identity of those individuals.
Yes, as I started mentioning a little bit ago, two attorneys from the Mitty Foundation, however you say that. Then we had a meeting that Monday afternoon, a video meeting over Zoom with Mr. Mateer. The following day, we had a telephone conference call with Mr. Maxwell. And then the next day, Wednesday of that week, we had a rather lengthy conference call with Mr. Penley.
then did you summarize those facts as you knew them within this report that I provided to you, which you had drafted around October 28th?
Yes, I took detailed notes, and then I wrote this fact summary and the rest of the memo after that.
Very good. And again, I'm not going to go into you about the specifics in your report. You're here to testify about your memory. So let me ask you, as a result of your conversations, let me back that up. Would you call what you did an investigation?
I would call it a preliminary investigation.
Would it be fair to describe it as a limited investigation?
Yes.
So in this preliminary limited investigation, you spoke with multiple individuals, and were you able to identify in your mind possible criminal offenses?
Yes, I was.
And who would have been the subject of the possible criminal offenses?
Primarily Ken Paxton, but there were other individuals that were also identified as potential suspects.
Very good. I'd like to ask you which offenses you identified, and I'm going to ask you one by one to just go slowly. Could you tell me, please, what you believe the first potential offense you identified was?
Potentially bribery.
Bribery. What else did you identify?
Accepting a gift to a public servant.
Very good. Next.
Abuse of official capacity under 3902 of the Penal Code, which has two different ways of committing the offense. One is misusing something of value belonging to government for an improper purpose. Second part is violating a law relating to your office or employment, and I believed that there were potential offenses under both of those sections.
Ms. Bonella, could I please ask you to bring up on the screen the three potential criminal offenses that have been identified?
Objection, Your Honor. We all know that Ken Paxton has not been charged with anything. This is completely improper. Possible criminal violations. This is completely improper.
Your Honor, this information goes directly to rebut inferences provided by the defense team concerning any possible investigation that may have occurred. Additionally, it goes specifically to articles of impeachment regarding potential abuse of power, potential bribery. Many of the other ones we're about to elicit from this witness, Your Honor.
May I be heard one further time, Your Honor? Imagine that it would be proper in a court for somebody to come here and say, he's possibly did this, possibly did that, possibly did this. Incredibly improper. That's pure speculation. He hasn't been charged with anything, and even if he were charged, he'd still be innocent. So this is completely improper, and I object to it because it's speculation.
Mr. Busby, I apologize for interrupting. If I may, Your Honor, just briefly, this witness is here to testify to his perceptions, his opinions. They are opinions that can be challenged. He is a lay witness under Rule 701, and he is using his information and rationally based on his perception is providing opinions which would be helpful to the jury to understand a fact and issue. He is available to be cross-examined by Mr. Busby, who I'm sure will take him on cross-examination and test his credibility.
He hasn't responded to the objection, which is this is all speculation. I mean, he could say that about everybody here. Possible this, possible that. That's why, as the gatekeeper, the court can't allow it.
And, Your Honor, again, I've responded directly to it as a Rule 701 lay testimony.
Just hold it.
I apologize.
I got it. Overrule the objection. Go ahead.
Thank you. Ms. Manella, if you would, please. Sir, as I bring up on the screen, I just want to make sure these are three that you have identified here in court. Is this an accurate and correct summary of the testimony you've provided up to this point?
It is.
Please, sir, the next potential offense that you've identified.
We were also concerned about some election code violations if certain factors came into play about how money may have been transmitted or handed over. And along those same lines, money laundering under 3402 of the Penal Code.
Money laundering is listed now on here. Is that accurate and an accurate summary of what you've stated?
That is.
Very good. What is the next offense that you identified?
tampering with a governmental record and possible perjury related to personal financial statements filed under Chapter 572 of the Government Code.
And Mr. Cox, I'll ask you as you turn to the side, just make sure to keep your voice up so we can all hear you.
Yes.
Please, sir, what's the next one you identified as a potential offense?
Coercion of a public servant under 3602 of the Penal Code.
And again, what's shown up on the screen, does that accurately reflect the testimony you provided?
It is.
Next offense?
Official oppression under 3903 of the Penal Code and retaliation under 3606 of the Penal Code.
Again, those two that have just popped up on the screen, do those accurately reflect your testimony?
Yes.
Next offense that you potentially identified?
We discussed whether there could be under Penal Code 1502 of the Penal Code or under Penal Code Section 7102, either a criminal conspiracy to commit any of these offenses, including the ones that haven't been put on the screen that I mentioned, or engaging in organized criminal activity with connection to these offenses.
Was there also an identification of a potential government code section violation?
Yes. Chapter 572 of the Government Code not only has the financial disclosure rules, it also has standards of conduct for state employees in subchapter C, and there was what appeared to be a fairly clear violation of one of the provisions of that section.
Sir, the information that's displayed on the screen now, is this an accurate summary of your testimony here today, specifically as to the potential offenses that you personally identified?
Yes, it is.
Your Honor, I've marked for identification purposes exhibit number 660, which is the entirety of what is shown on the screen, and I would offer the same into evidence as summation.
It is admitted into evidence.
Thank you, Your Honor.
Did you object?
I was going to, Your Honor.
I'm
But
sorry, excuse me.
why don't we-
I thought you had already allowed it earlier and had not been admitted. So state your objection.
Why don't we write on there that accurately reflect the testimony of potential or possible instead of just putting the statutes on there? The witness clearly said that he speculated this might have been some offenses. And so it would be really improper to put that into evidence without clearly identifying that these are all potentials or possibles that have never been indicted on, ever.
May I respond, Your Honor? Or Mr. President? May I respond? I know Mr. President has indicated his desire not to have to look at too many numbers, so I'm probably going to make it worse by suggesting the following, but the Texas Supreme Court under Uniroyal Goodrich Tire versus Martinez and Inspire versus Webster College have adopted the charts that summarize or perhaps emphasize testimony are admissible if the underlying information has been admitted into evidence. This is simply a summary. Mr. Busby may question the witness at his leisure concerning the qualifications and any particular changes that he believes are appropriate for this jury to understand.
But, Your Honor, it has to be a fair summary. No one's challenging that you can do a summary, but it has to be a fair summary, and that's not fair.
I'm going to sustain the objection. You were allowed to bring it in. He said these were possible, so I'm going to sustain the objection.
And so can we have it, if it's going to come into evidence, write possible on it or potential? That's
Yes.
Yes, thank you.
Do you agree?
I'd be happy to identify it as the testimony which has been provided as possible evidence, and I'll even identify that it's by Mr. Greg Cox.
And then are you
If he
satisfied with that?
writes that on there, because that's going to be on the front page of the newspaper, and let's make it clear that this guy didn't have any evidence of that.
Your Honor, may I do that at a break so as not to take any further time, but before formally submitted in evidence?
Yes, on each one, each item.
Yes, Your Honor.
All right.
Mr. President, excuse me. Either. Thank you. Sir, after you've identified these possible potential offenses, and again, this is your opinion, and as you've described to us, you have worked in the criminal field for some 30 years. Is that accurate?
Correct.
What, if anything, did you do?
After discussing this with Margaret Moore, the decision was made to reach out to the U.S. Attorney's Office, make sure that moving forward with an investigation would not interfere with any ongoing federal investigation, and I was tasked with making those calls and setting up meetings about that.
The Chapter 572 of the Government Code offense that you flagged, was that one that you discussed with Margaret Moore?
I believe so, yes.
Do you recall the complete language of Section 572 of the Government Code?
Not off the top of my head.
Could you recite it off the top of your head?
I could not.
If you had a copy of the statute, would it assist you in providing your testimony here today?
Yes, it would.
Your Honor, for identification purposes only and not for admission, I'd offer 661 of the House Board of Managers exhibit to the witness and to counsel so they may review as the witness testifies.
Are you bringing it forward?
Yes, Your Honor, but again, not offered into evidence, but merely for purposes of reliance during his testimony.
Okay.
May I have a copy?
Yes.
Sir, could you identify for us, and you don't have to read directly from it, but are you familiar, after having looked at this document, with 572.002?
Yes, I am.
And does it provide, tell us what your thought process was, and if you need to refer to the document, please do, but what your thought process was as to why this would be a potential violation?
Well, actually, 572.002 sets out who the various officers are that are subject to this. 572.051 sets out the standards of conduct. And what I referenced earlier in my testimony about the violating a law related to his office or employment under 3902 of the Penal Code, this would constitute a law relating to someone's office or employment. And the subsection A says that a state officer should not accept or solicit any gift, favor, or service that might reasonably tend to influence the officer or employee in the discharge of his official duties, or that the officer or employee knows or should know is being offered with the intent to influence the officer or employee's official conduct.
So after flagging these potential violations for your elected district attorney Moore, what actions did you take?
I reached out to the U.S. Attorney's Office, spoke with the then manager of the Austin branch of the U.S. Attorney's Office, Ashley Hoff, and we ended up setting up a meeting.
Was the idea to reach out to the local United States Attorney's Office yours or Ms. Moore's?
I believe it was mine, although I can't say that Ms. Moore didn't also suggest it.
Was there any concern, well, let me ask it a different way. Was there any concern about an ongoing investigation?
So much of what we were talking about related to Nate Paul, and we knew that Nate Paul was the subject of a federal investigation. We were concerned that if we jumped into this and opened an investigation, we were going to interfere with an ongoing federal investigation. So we just wanted to basically deconflict with the feds before we took any action.
Is that common, that deconfliction, is that common?
That is common.
Don't want to run into each other on the investigation?
Correct.
Want to make sure the witnesses know that there are potentially two tracks going?
Exactly.
Fair enough. Do you recall who all you, well, let me ask you this. You set up a meeting, correct?
Set up a couple of different meetings. Initially, we had a conference call, Margaret Moore, Don Clemmer, and myself from the district attorney's office, Greg Sofer, Ashley Hoff, and Christina Playton from the U.S. Attorney's Office. And we talked through a lot of the facts, and then we agreed to have an in-person meeting the following week. In between those two meetings, I was advised that because Mr. Clemmer and Ms. Moore...
Objection, hearsay.
Sustained.
Can you tell us whether or not there were multiple people from your office who were supposed to be meeting with the U.S. Attorney's Office?
When we set up the in-person meeting, I was the only person attended so that no potential witnesses were involved.
And did those potential witnesses include individuals from your office?
Correct.
Fair enough. Without getting into the content of what was discussed at that meeting, did you believe you had a path forward to continue your investigation?
That's what we were trying to determine, was whether there was a path forward that did not interfere with a significant federal investigation that was going on.
Did you believe that you, after that meeting, had a path forward?
After that meeting, I was still unclear. The in-person meeting we had included people from Washington, D.C. that came down for the meeting. And then shortly after that meeting, I had a telephone call with someone from the U.S. Attorney's Office, and at that point, we stood down.
You stood down. Was that your desire to stand down?
I was frustrated by that.
Is it fair to say that you had additional investigation that you wanted to achieve?
Yes.
And I should phrase that differently. Was it something that you wanted to achieve or you felt the evidence would lead you to follow?
It was something I felt was worthy of investigation. It involved important issues involving the state of Texas, and I was concerned that, as I had seen happen too often, the federal government would sit on it for a long time, and then we might not see anything happen.
Does that appear to have been the case thus far?
It does.
Finally, sir, as you were going through section 572.051, I'd ask you to take a look at subsection D of that statute.
Yes.
As it relates to the testimony that you previously provided, that an officer, an employee, a state officer or employee should not solicit gifts, favors, services, or bribes, does it indicate who is responsible for drafting the policies that would go throughout the entire state?
Subsection C of that statute says that each state agency shall adopt a policy, and it places the burden of drafting a model policy of these standards of conduct and making sure that ethical policies are in place on the Attorney General.
I'll pass the witness, Your Honor.
Mr. Busby, we were going to break in 5 minutes. We can go 10 or 15 if you want to start, and then we'll break, or do you want to break now? Okay. Members, we'll break now. This is your late afternoon break. We'll come back at 5:15, and then we'll go to about 7. bailiff, please bring in the witness. Looks like I'm missing a juror or two, or one anyway. A few over here. I believe we have everyone. Mr. Busby, your witness.
You know, they say that you can indict a ham sandwich. You ever hear people say that?
I've heard that saying.
In fact, you recall that the former governor of our state was indicted just for exercising his veto. Remember that?
He was not actually indicted.
He was indicted. Governor Rick Perry was indicted for exercising his veto. Did you not know that?
I thought they did an investigation that resulted in a no bill.
No, you're misinformed. He was indicted by a Travis County grand jury. Did you not know that?
I did not know that.
And he said over and over and over, my gosh, all I did was exercise a veto. You can indict a ham sandwich.
Respectfully, I object to this line of questioning as being wholly irrelevant.
Overruled.
So here we have a Travis County, in Governor Perry's case, a Travis County grand jury indicted him for exercising his veto, and you just went through this litany of possible maybes with regard to Ken Paxton, didn't you?
That's correct.
He might have done this, he might have done that, right?
Correct.
I guess what you were saying is that, hey, I'm analyzing the law. If any of this foolishness is true, this might be the criminal violations, right?
That would be accurate.
And you know for a fact that you're not supposed to come into a court like this and testify about what somebody might or may have done. Isn't that right?
I was answering the questions that were asked.
You would have never, have you ever been in court before as a prosecutor?
I have.
So you know for a fact that that is not proper, don't you?
This is not a criminal trial.
Right. It's not proper to go into a court and testify on live stream and to jurors about something that someone might have done. That's incredibly misleading, incredibly prejudicial, and wrong, isn't it?
Objection, Your Honor, to asked and answers mischaracterizes the evidence as presented by the witness.
Overruled.
I was asked to identify the possible avenues of investigation that I outlined in the memo to the district attorney.
Possible, maybe, potentially. We don't know, right? You don't know it all, do you?
I don't understand that question.
You were just sitting up there and making a bunch of silly guesses, weren't you?
I would not agree with that.
And you just testified in this historic impeachment proceeding in response to the House's questions about all of the potentials, or the maybes, or the possibilities, right?
I was talking about the memo that I wrote for the district attorney outlining the avenues of investigation had the feds not waved us off and we had moved forward.
The feds waved you off, you say?
Yes.
Y'all were excited about this. We got a chance to get Ken Paxton, isn't that true?
That's not accurate.
Let's look at Eric, AG Exhibit 170, Brickman 202. You tell me if this is right. It's in evidence. Bring that right there on 10/27/2020, Eric. Right there, Eric. Let me just read this so we'll understand what y'all really were up to. My phone conference with Margaret Moore and her team went well today. They are excited about pursuing this investigation and will coordinate their efforts with the U.S. Attorney Office so that both pursuits complement each other. They obviously want to move quickly as they have time constraints. They are not going to wait on the feds. Did I read that right?
You read it correctly, yes.
So the DA's office of Travis County, Margaret Moore, she Democrat, Republican?
He's a Democrat.
Okay, so the elected Democrat district attorney of Travis County was excited. She had a chance to go after Ken Paxton for just an entire litany of things, according to your little memo, right?
I disagree with the description of excited.
And you're telling me that the feds waved her off. That's what you're telling me?
Correct.
The feds under whom? Who was in charge of the feds?
At that time, I believe it was still Attorney General Barr.
Okay, who was the president at that point in time?
Donald Trump.
Oh, think about that for a minute. You're telling me that this elected Democrat, who you claim the maybes, the possibilities, the potential, all kinds of crimes, that she, as an elected Democrat, decided, stand down. Donald Trump says stand down. You think that we really believe that foolishness? Do you think we believe that?
I have no idea what
Nobody
you believe.
believes that. And you don't believe it
Objection,
either.
Your Honor.
Do
I
you?
object, sir, thank you, to the form of the question and offering an opinion that he is not entitled to offer in testimony.